Thank you. Good morning, and welcome to the December 14th sitting of the Massachusetts Appeals Court. My name is Catherine Hand, and I have the pleasure of sitting today with Justice Rachel Hershfang and Justice Robert Brennan. We have 7 cases on our list today. We're going to take a morning break, I expect, after our 4th case. The ground rules for today, as I'm sure you're aware, include the fact that each side has 15 minutes to argue. There is no rebuttal in the appeals court. You'll notice on the podium a set of 3 lights. The light, when you begin your argument, will show green for about 13 and a half minutes. When it gets to 90 seconds, the light will turn yellow. When it turns red, I'd ask you to stop unless you're finishing your answer, in which case, please finish that answer and then stop. We have read your briefs. We are very familiar with the record and the background of your case, so keep in mind that your time is limited, and please feel free to jump right into your argument. And counsel, I'd remind you that several of the cases today are either fully or partially impounded, so please be mindful of that fact. Please do not use the parties' names on any impounded or partially impounded case, and be mindful of the parameters of the impoundment order. Thank you very much. Okay, so calling our first case, Commonwealth versus Scott A. McCaffrey, 2023 P0020.
Good morning, Your Honors. May it please the Court, my name is Emma Quinn Judge. I represent the defendant, Scott McCaffrey. We're here today asking this Court to reverse the convictions for aggravated rape on 2 bases. First, that the amendment to the indictment, and second, the failure to include the lesser included offenses in the jury instructions. We're also raising a host of issues, as you know, that are evidentiary, as well as related to jury instructions. In closing, my plan, unless you instruct me otherwise, is to start with the indictment issue, and then to move on to some of the evidentiary issues and the lesser included jury instructions, just to give a roadmap of where I'm planning to go. But I'm happy to go somewhere else if you direct me there. So with respect to the indictment issue, amendments to indictments that are substantive are not permitted. And I want to start maybe with what we're not arguing today. We're not arguing that Mr. McCaffrey was prejudiced by the amendment to the indictment, because that is not an issue where the amendment is one of substance. The appeals court said that in McGilvery. The SJC has said that going all the way back to Commonwealth v. Snow. So we are arguing that the amendment is substantive, and I think the question for this court to resolve is that issue. Is it substantive or an amendment of form? The test for that is fairly simple. It's outlined in Knight and from other cases. An issue of form is something that's not essential to the description of the crime charged. And here the amendment of the indictment changed 2 things. It changed the age gap and it changed the age of the victim, both of which are things that are essential to the crime charge. You don't have an aggravated rape charge without those factors. It's not surplusage in the amendment. It's not the sort of thing that can be taken out. And the cases are clear on this issue. There are cases about changing from one subsection to another, and in those cases, the courts have repeatedly found that a change from one subsection of a statute to another is an impermissible amendment. And that's true whether this penalty is more harsh, as it was in Sousa, which is a gun weapon case, and when the penalty is less harsh, as it was in McGilvery, which is a drug case. There are also cases, if you think of the aggravated rape statute as charging one offense with multiple theories, there are cases about that too. There are cases where the indictment has reached one theory of an offense, but not others, and courts have consistently said you can't change theories either constructively or by amending the indictment.
May I ask you a question?
Sure.
Sorry.
No, go ahead.
Do you agree that jeopardy would have attached for one or the other? So whether you went under subsection A, if there was a not guilty there, the Commonwealth could not come back and re-prosecute under subsection B, and vice versa. If they went forward on B and there was a not guilty, they could not re-prosecute under A, under these facts.
I don't, in fact, because I think the way the double jeopardy test works is that this is, these two offenses are mutually exclusive, right? One is a child under 12 and one is a child between 12 and 16. So you couldn't charge the same offense under both subsections, right? They are separate in that sense.
On this one, though, more than 10 is by definition more than 5.
That's with respect to the age difference.
With the age, right.
With respect to the age
But you say
difference.
the age itself is for sure under 12 versus 12 to 16.
Right,
Okay.
the age itself is mutually exclusive. And so my understanding of the way the double jeopardy test works, and I find it hard to get my head around, right? Because he was tried for these offenses as far as we can tell, right? But if the indictment was improper, the only thing he could have been tried for was what was in the indictment. And so my understanding of the double jeopardy test from having read these cases is that he could then go back and be retried under the correct section of the indictment.
So let me ask, so hypothetically, if a person were indicted for rape of a child, and I'll tell you this, if they were just indicted for rape,
Yeah.
okay, and the person is 17 years old, and it's a not guilty, and then lo and behold, or vice versa, they indict for under 16. You know what I'm saying? I'm mangling the question, but the idea is, if I'm just having a hard time finding that, I'm having a hard time understanding how
help
this
you?
is not double jeopardy.
Can I try to help you?
Yes, please.
I may not succeed, but the indictment alleged rapes of a particular person, right? There was only one victim in this case, and the victim was identified to the grand jury
Correct,
by name,
correct.
and all of the allegations about what your client is said to have done related to this particular named victim whose identity was known to the grand jury.
Correct.
So the question I think that you are asking us to answer is, if the age of that person was misidentified in the indictment, though not parenthetically in the evidence that was presented to the grand jury, then to circle back to Justice Brennan, has jeopardy attached on the charge with the wrong age?
My understanding is that jeopardy has only attached on the charge as indicted, and the charge as indicted was for the wrong age, and so that there would be a possibility of retrial on a corrected charge. One parenthetical on that is, just to complicate things, for the lesser included issue, if this court concludes that lesser included instructions should have been given, then the aggravated rape charge on a reversal would be taken out, and you could only retry on the lesser included. But that's not the double jeopardy test for the indictment purposes. I'm just throwing that out there because of the intersection.
I guess where I'm going is, it's hard for me to imagine that you or any other excellent defense lawyer presented with a not guilty on the trial with the wrong age would turn around and say, okay, well, I guess you can retry with the corrected age. Jeopardy did not attach.
I think if there was a not guilty on the trial with the wrong age, you know, I could certainly counsel would make the argument, but I think the court could correctly find that some person had not been tried for that offense, because that's in these cases where there are substantive amendments. Generally, there has been, not always, sometimes the amendment happens at the end, but generally there has been an amendment before the trial, and the court treats it as jeopardy not having attached because of the fact that these are distinct offenses. And that's my understanding of the double jeopardy test, and my understanding for the purposes of this argument is that I have to concede that he could be retried for the corrected offense.
One of the other ways that this test is expressed, and I'm looking at Commonwealth versus Bolden, the sixth footnote, is a question of whether the amendment materially changed the work of the grand jury. Here, I think both sides have frankly stated that the grand jury had all the appropriate information. It appears to have been, you know, for want of an accurate term, a scrivener's error by the Commonwealth in presenting an indictment that actually just had the wrong age in it. And I understand scrivener's error doesn't actually cover this situation, so please don't think I'm suggesting that, but they messed up. How would you address that materially change the work of the grand jury expression of a substantive amendment?
So this entire issue obviously is draped in constitutional ramifications because of Article 12, right? And Barbosa says you can't be convicted of a crime without being first indicted for that crime. And so there are constitutional considerations. The reason Bolden gets to that issue, the materially changes the work of the grand jury issue, is because Bolden is a change of form, not substance. It's a name change case. So if you look at Knight, for example, it does a nice job laying out the analysis. When you have a change of form, you have to say, okay, it's a change of form. Second question, was there prejudice? Third question, did it materially change the work of the grand jury? So that's a consideration when you've got a form case. It's not part of the analysis on the substance case where the only question is whether something was essential to the description of the crime charged. And that's where I go back to the fact that the age here is essential to the description of the crime charged. You don't have this crime without the age being charged. And I've seen no cases where an element of the offense, and age is an element, I think we can agree on that, where an element of the offense was changed and that was permitted. You have cases where name or date are changed. Those are questions of form. You have cases where indictments are pruned. They allege all the theories and then they're narrowed. And you have the Miranda case where you have the repeat offender issue and you sort of smush some indictments together because it wasn't a freestanding. But again, it's not changing an element in none of those cases. Whereas all the cases where an element is changed, is added, you varied between subsections, you varied between theories of an offense, all of those cases have said this was impermissible. It was a matter of substance. It was a matter of substance and not form.
Taking a step further back, you noted that this is a constitutional defense or constitutional right, which obviously it is. At the foundation of that right is notice, right? It's a due process right, so the defendant has a right to be on notice of the crimes with which he or she is charged. Is there any argument here that the notice element of the due process right was not met here?
I don't think there is, but I also don't think that matters if you look at the cases on this, right? Because in McGilvery, this is the one where the drug charge is reduced. There's no surprise because it was revealed in discovery. In Snow, which is the sort of seminal 1930 case, the defense counsel says, I'm not able to identify any prejudice. I can't. And the SJC says, yeah, that's fine, because it's not about notice. It's about preserving the role of the grand jury. I think the notice piece is a different constitutional dimension. In Ruy Diaz, where you add an age that's undisputed, that the victim is over 60, again, there's no problem. So a lot of these cases have that feature where there is no notice problem.
And actually, though, in McGilvery, for example, yes, I agree with you on the one hand. On the other hand, part of that, that's central to that, was the Class A versus Class B had a different penalty structure. And for subsequent offenses, at least back then, subsequent offense Class B was a 3-year min-man and the Class A was a 5-year minimum mandatory. On the over 60, comes with an enhanced penalty.
Right.
Here, it's different, right? I mean, the same penalty regardless of whether it's charged under subsection A or subsection B.
That's true, but then if you look at Garcia, which is the constructive amendment, if you look at the cases around theories of the same charge, Garcia is a constructive amendment, sexual intercourse versus unnatural intercourse. Williams, you have multiple theories of motor vehicle homicide. Mayotte, you have multiple theories of reckless endangerment of a child. In all of those cases, you're talking about the same offense, but because there are multiple theories of the offense and only one is indicted, amendment is not permitted. I mean, so either way you frame it, whether it's
Mayotte, though, is a serious bodily injury as a theory of reckless endangerment as opposed to sexual assault, right? So
yes.
Those are substantively, materially different. In here, we're talking about someone 12 to 16 or under 12, and I just don't know that it's the same. Maybe it is. I just don't know.
Could I just piggyback onto that question maybe and say, is Garcia your best case for the proposition that the difference in theory is dispositive where the offense itself is under 16 years of age? So the offense is rape or unnatural intercourse, sexual intercourse or unnatural sexual intercourse of a child under 16 and AB,
right.
Distinguishing.
Garcia is closest on that. I mean, I think Williams, you do have the multiple theories of motor vehicle homicide in the second set of issues in Williams. There are two different amendments at issue in Williams, but I agree with you that Garcia is probably the closest. I'm going to try very briefly to piggyback, to jump to a couple of other issues, if that's okay. Very briefly, the issue of bolstering the victim's account through the issue of improper testimony. Primarily, I'm focused on the officer's testimony here. That is the sort of testimony that the SJC described in Stuckich as extremely prejudicial. And the Commonwealth's assertion here is that it's relevant to explain the state of police knowledge in the case and the lack of physical evidence. Well, defense counsel didn't make an issue of the lack of physical evidence. The defense was it just didn't happen. It's all made up. And if you look at the case law on explaining the state of police knowledge, there are a couple of requirements that just aren't met here. One is that anything, even if you take the Commonwealth's explanation at face value, one requirement is it has to be carefully circumscribed to only reach that issue. And if you look at Mr. Marquardt's testimony, he testifies about all sorts of things, and then right at the end there are two questions about and the lack of physical evidence. We wouldn't have physical evidence in these cases. The other requirement is that it be responsive to an issue in this case, and I just don't think it is responsive to an issue in this case. Very briefly, on the lesser included issue, I think we all agree that an instruction has to be given if the evidence rises to that level, and that the Donlan case is instructive. And I agree with the Commonwealth on that, because in the Donlan case, the defendant denies the allegations, and the testimony on penetration is unequivocal, adequate, and unchallenged. And so we're not saying that the testimony on penetration here isn't sufficient. We're not making a sufficiency challenge at this point. The question is whether, viewed in the light most favorable to the defendant, there's enough evidence for there to be a question on the issue of penetration. And Donlan talks about another case where defense counsel extensively cross-examined the principal victim on force and threats. That was the element at issue there, such that in the light most favorable to the defendant, there might be an issue. And here, defense counsel...
Could I interrupt you, and I'm sorry to do it on your last minutes, but do you have, even viewing the evidence in the light most favorable, do we still take reasonable inferences from the testimony? Do those have to be reasonable, I guess, is the question that I'm asking?
The case law talks about a rational basis, which is probably reasonableness, and then it talks about viewing the evidence in the light most favorable to the defendant. And there is extensive cross-examination on the inconsistencies between the prior statements and the statements at trial, including with respect to where the victim was touched for the various offenses. And we flagged that evidence in the brief. I'm not going to repeat it. But I just want to make clear that it's not a sufficiency argument on the penetration evidence. Thank you.
Thank you very much.
Thank you.
Good morning, Your Honors. If it pleases the Court, Arna Hansen for the Commonwealth. ADA Cusman, who handled the trial, is also in the courtroom today. She is seated with the victim and her family, who are also in the courtroom today. With respect to the first issue, whether or not this was a change of form or substance, it's clear that this is a change of form. There was no change in an element here. So to prove the aggravated rape of a child under 265-23A, there's three elements. So there needs to be sexual conduct, so either intercourse or unnatural sex. The victim needs to be under the age of 16, and then the aggravated portion, so what separates 23A from 23, just rape of a child, is the age difference. So that's the third element. That element never changes. There's always, whether it's under 23A or 23B, that's the age difference is aggravated, the aggravating portion. What changed here was which subsection. And clearly this was a clerical error, but because the three elements are unchanged, there's no substantive change here. Now, there's a number of ways that the court can evaluate this, and certainly jeopardy is one of them. Jeopardy certainly applies here, where the defendant, the indictment set out very specifically what sexual acts on which days with which victim in which location constituted the various crimes that the defendant was indicted and ultimately convicted for. To suggest that he could then be retried for those exact same acts without adding any different elements, I just don't see. Certainly jeopardy is attached. Now, the other consideration for this court is whether or not this changed the work of the grand jury. So was the defendant convicted for something that he wasn't indicted on? The evidence here certainly supports the amended charge. And the grand jury heard the testimony that this occurred when the victim was between 8 and 10 years old. That was very clear. They heard that the defendant was born in 1966, so at the time of these incidents, he would have been in his mid to late 40s. So certainly there's a 39, 40-year gap between the victim and defendant. So the aggravated portion was properly presented to the jury, but when the indictment was written, it was charged in the wrong subsection.
I'm not understanding as clearly as I'd like to what the difference is between this and something like Garcia, coming back to that case again, where, if I understand your argument correctly, it seems to me that you're saying that Garcia was not correctly decided. Is that true?
Well, with respect, I believe in Garcia, the issue was the sexual acts. And I think there might have been a dispute as to whether the indictment was proper and whether the Commonwealth had presented the certain evidence to the grand jury in that case and whether that was presented to the trial judge. So there might have been an issue of whether or not they were properly on notice. But I don't believe that's the case here, where these sexual acts, and it's very clear from the indictment what these sexual acts are, and would certainly allow the defendant to properly prepare his defense, and he certainly had proper notice of the charges against him.
Is it your position that Section A and Section B are lesser included offenses of each other, or do you concede that they're distinct offenses?
They'd certainly be, they're distinct. I mean, they're mutually exclusive. You can't, under the same charge, a person can't be under the age of 12 and then also between 12 and 16. Now, with respect to whether or not there's a change of substance, there's no new elements introduced. So that's another thing that the court can consider under Williams and Souza. Here, certainly if there was an amendment from, let's say, 23A, so aggravated rape of a child, to, let's say, aggravated rape of a child by force, there the third element is uniquely distinct. So it changes out the age difference element versus the force element. So that would certainly be a substantive issue, because third element is different and it requires different proof and different evidence at trial, which is not the case here.
Well, I mean, if it's not an element, then what is the age difference requirement? I mean, let me ask that in a sort of slightly more lawyerly way. Is it something the Commonwealth needs to prove at trial?
So, yes.
And is it something that the jury renders a special verdict on at trial? In other words, I just don't know how these cases are tried. Is there usually or often or here a special verdict form in which the jury needs to say, yes, the child met this age requirement?
I'm not familiar what was on the verdict slip. I'm not sure I'm in a position to answer that question. It's certainly an element, but my argument is that the aggravated portion, so the age difference is the element. So that hasn't changed in this case.
Well,
But there's two ways for the Commonwealth to meet the aggravated portion. To, one, demonstrate a gap of 5 years and that the victim was under 12, or if the victim is older, the Commonwealth and the legislature requires that there be a larger gap in order for this to be aggravated.
So I just want to make sure I'm understanding. So your position would be, for example, that if the victim were, that really in order to prove either A or B, there's sort of a merged requirement of age of the victim plus age difference, and it doesn't matter which of those A or B the Commonwealth proves, as long as it proves one of them, it has met the requirement of this aggravating factor.
Correct.
Do you have what's your best case for the proposition that we should read this statute that way?
I'm not sure I have one. This is obviously an issue that has not been litigated before. I think if you look at Williams or Souza, in those cases, it's clear that they changed the elements that were required. So for Williams, the motor vehicle homicide, it introduced a different theory altogether, which required additional evidence and different elements that needed to be proved, which is not the case here. And again, with Souza, that's the gun case, where the court found that there's the carrying a dangerous weapon versus carrying a firearm without an LTC requires substantially different proof as well. So dangerous weapon, you'd have to prove that it was, a knife, a bladed weapon, etc. With a firearm, you'd have to prove that, one, it was a firearm, a functioning firearm, and that the person didn't have an LTC. So there's certainly elements that differentiate that here.
Did your position that this is a simple test, as in not essential to the description of the crime, or that is a multifaceted test and we look at different factors?
Oh, it's certainly a multifaceted test because we look at we look at several issues, whether it materially changed the work of the grand jury, whether it added new elements, whether double jeopardy applies, whether the indictment was sufficiently clear. And I think if you look at each of those questions here, the answer is no. It didn't add any new elements. It didn't make the indictment unclear. It didn't change the work of the grand jury. Was there prejudice? No.
So again, just so I'm clear on this, because Attorney Quinn Judge started by saying, test is very simple. Was this essential to the description of the crime? Plain and simple. You see it differently. You see it as a more nuanced analysis?
Correct, because if you review the case law and if you look at, Knight, Benjamin, Rudall, Allison, Murphy, all the cases that I cited in my brief, they all address it in one of many different ways. I feel the most appropriate way to address it is to take the test from each of those cases and apply them to this case in particular.
And so if I understand you correctly, and I'm trying to walk through this, I'm looking at maybe 5 factors. Did the grand jury indict essentially for the same crime? Did jeopardy attach? Was the defendant on notice? Was this a lesser included? And is it the same penalty? Am I missing something, or does that pretty much cover it so far?
Did it change the elements? Did it introduce any new elements? So I think that's what Williams and Sousa really stand for.
Which would sort of be akin to a lesser included, I suppose.
Yes,
Okay.
That's fair.
Do you have, this is like the pop quiz portion of the oral argument, so I apologize for that. And it's okay to be unprepared because pop quizzes are like that. Do you have a case that stands for the proposition or that addresses a situation that is procedurally similar to what appears to have happened here? Namely, the grand jury was apparently presented with all of the evidence it would have needed to indict on the charge that the Commonwealth eventually amended the indictment to, but due to a clerical error, indicted on a different charge. Or I don't want to say different because that sort of begs the question, but something that had different words in it.
So Benjamin is a case that I reference. It's 358 Mass 272. That case addresses the issue of whether it's a change of substance, and that case specifically says, does it materially change the work of the grand jury? There's certainly a lot of case law in the other direction, not necessarily in this context, but whether or not the analysis being whether or not the defendant was convicted of a crime that he was ultimately indicted for. So Barbosa, which defense counsel mentioned, and I also referenced in my brief, is a case that essentially says the opposite, where the grand jury doesn't hear that testimony, then the defendant can't be convicted.
And just as I read the grand jury minutes, actually, when the letters were presented, presumably the prosecutor just said, then we have aggravated rape, and that's aggravated by the age difference, without specifying what age difference. Does that have any significance to us at all, or is?
Again, yes, so that goes back to my other argument of the element is the age difference. So that never changed. What really what happened here was there's a scrivener's error and it was corrected. And either way, it's not necessarily material because it doesn't really change the defense for the defendant. He's given notice. He knows exactly what he's being charged with. He knows that this occurred when the victim was between 8 and 10. He knows where it occurred and, the specifics of each crime charged. So it wouldn't have changed his defense. It would certainly be an issue if the Commonwealth said this happened when the victim was 8 and 10, and then 3 months or the month before trial actually says, well, actually, we were off by 4 years, and this actually happened when she was 13, which is not the case here. Does the court have any additional questions for the Commonwealth?
I mean, maybe.
No, thank you. I think
Thank you. I rest on my brief.
Thank you.
Thank you.
Thank you both for your excellent briefing and for your arguments. The case is submitted. Our next case is 2023 P0496, Commonwealth versus Kipeum Lee. This matter also is partially impounded, and I'd remind the parties of that. Good morning.
Good morning, Your Honors. May it please the Court, Andrew Power for Defendant Kium Lee. I'll begin with the Batson issue, first issue in my brief. And I just want to make one point right off the top, and that is that a party can challenge a juror for cause on the basis of racial bias. But once the judge makes a determination that that juror stands impartial and that juror stands indifferent, the matter is settled, the matter is decided. The party cannot then make a peremptory challenge based on the same grounds, racial bias, because the Constitution forbids peremptory challenges based on race, and racial bias is related to race.
It's related, but is it the same thing?
Yes, it is. Once a juror is found to be impartial, then what's left? The judge has found that the juror is not biased. The juror stands indifferent. Well, what is left? Race. The cases are clear. It has to be something else. The peremptory challenge can be based on the fact that, the juror's mother is a police officer, or the juror's a teacher, and there are teachers involved in the case.
Counsel, let me
Well,
ask you, I'm sorry.
Sorry, just to follow up. In this case, the judge found that the juror was indifferent on the matter of racial bias. The record also included responses from the prospective juror as to how she might or might not view evidence because of her own implicit bias, for want of a more artful term. Was the lawyer obligated to ignore those answers after the judge had ruled that the juror was indifferent?
The lawyer was obligated to follow the judge's ruling. So as long as all of those answers were presented to the judge and considered by the judge, and the judge made a ruling, that settled the issue. The judge heard all those answers, and the judge, I think, engaged in really a model voir dire colloquy with that juror and brought her along and talked to her about the responsibility that we have. You can't disregard who you are, you can't disregard your identity, but coming into the courtroom, jurors are required to focus on the evidence and decide the case only based on the evidence, the testimony of the witnesses, making credibility determinations. And I thought the judge did a really good job of that. And eventually, the juror came around to a big yes, I can. I can decide this case impartially and without regard to race. And the judge found, I credit you. She credited that juror and found the juror to be indifferent. So
can I
that's
ask
when
So
it
as
was
defense
settled.
counsel who is zealously representing your client's interests, you then are obligated constitutionally under Batson, I think this is your position, to ignore the fact that that juror's first responses to those questions were, yeah, I probably would be biased in favor of the defendant.
I just want to clarify that she didn't say I probably would be biased in favor of the
Fair.
defendant. She said her responses were very equivocal. She said maybe, could be, and it was simply I might be more lenient towards Asian people because I am Asian. And it was also in the context back then of violence
Of course.
committed against Asian people in the community, because I think that's what first brought it up in her mind. And eventually when she was, and I think it's the Williams case that I cited in my brief, the SJC has said, you know, jurors come to court with all kinds of backgrounds, and the judge is obligated to sort of help the juror to focus. I mean, there are implicit biases, and you can't set those aside. You can't ignore them, but you can focus on the evidence and follow the judge's instructions. So the juror said she could follow the judge's instructions. That's presumed to be true. The judge found the juror impartial, and that was the end of the bias argument, and all that was left was race.
Can I ask you to flip the script a bit and imagine, if you will, that the juror instead said, I would be biased against people of Asian descent, and equivocated 9 times, twice said, I probably or might be, just say I might be prejudiced against Asian people. But then as the judge teased it out and said, well, understanding all that, could you put that aside and be fair and impartial? And ultimately, after 3 or 4 series of questions, again, during which there, to my count, 9 equivocations and twice saying might be, instead of lenient, prejudice toward a person of this race or ethnicity, is it your position that the defendant could not have exercised a peremptory challenge on that juror?
I believe the defendant's remedy in that case would be an objection to the determination on the for-cause challenge.
And that the defendant then would be precluded from exercising a peremptory?
Yes, because the judge's finding precludes the peremptory, because the peremptory is basically, the peremptory can't be an end around the judge's finding. So the judge's finding that this juror is indifferent, well, I don't believe you, I won't abide by that, so I'm going to exercise a peremptory. That's sort of what's the whole point of credibility determinations in the judge, is that they are accorded great deference by reviewing courts. If a judge determines that a juror is indifferent, that settles the matter, unless it's something really egregious and the jurors, you know, biased. I also think leniency towards based on affinity is categorically different than bias against based on prejudice or racism, or so I think we also have to look at that.
One of the, and just to
of it.
clarify, when you say implicit bias, isn't this more of an explicit bias? I mean, implicit is unconscious, we don't know about it. This juror said, I might actually be more favorable towards someone. That's as explicit as it seems to me.
Well, I think it's an explicit acknowledgement of implicit bias that many people don't acknowledge. And I think everybody and I think counsel actually pointed that out at the time, that like, this juror is actually being honest with us and saying what is often unspoken, that people have affinity biases towards people who are like them. And that gave the judge the opportunity. It was actually good that she came out with that. So it gave the opportunity to the judge to tease that out, work with her on it, and kind of focus her on what she should be doing, as the SJC has asked courts to do. Now, this is, one of the cases I cited was the Prunty case, and that was a case that involved racism by the defendant.
But in Prunty, the juror never said they might be biased, or they would be biased, or they could be biased, nothing along those lines.
No, but bias, racism was an issue in that. White against black racism was an issue in that case. It was a black juror. The judge went through the evidence, or the expected evidence, asked the juror about it, engaged in a colloquy, and found the juror to stand indifferent, and same position. At that point, the defendant could not exercise a peremptory against that juror, because the judge had found this juror is not biased, and anything you exercise that's on the basis of race or on the basis of racism is barred by the Constitution, is barred by Batson.
Could I ask a separate question? What I think is a separate question, which is, putting aside whether the issue is racism or not, if that's possible, is not the ability to exercise a genuine and adequate, to provide well, let me start again. It surprises me to hear your argument that a peremptory challenge cannot be used where counsel disagrees with a judge's determination of a juror's impartiality, where it seems to me that the fact that on the basis of a for-cause challenge, the judge determines impartiality is one thing, but that the defense counsel or the counsel retains the ability to use a peremptory if they disagree, provided, in this instance, that it's an adequate and genuine reason is given for it. And is it your position that the reason can't be at least adequate if the judge has already made a determination of impartiality?
Correct. Well, an adequate explanation is one that is not based on the juror's affiliation, in this case race, and that's a quote from Maldonado. A challenge that is based on racial bias towards members of the same race is clearly based on a juror's affiliation, and so that would be inadequate.
I think
However,
you're
if it were-
conflating two things there, though, if I may. I mean, you know, Prunty, I think, actually puts a very fine point on this issue, which is, in Prunty, as you just said, there was no statement about racial tendencies of, you know, by the juror one way or the other. And so the court said that the defense counsel's challenge was based on an assumption that an individual who had suffered racism would feel subtle biases against an alleged racist. There's no assumption in our case. Ms. Lee's prospective juror actually said, I might feel, you know, more lenient, or whatever her actual words are, toward someone who was of my same race. Is there no space in the law for an objection based on a juror's expression of their likely or possible behavior that is separate from looking at that juror and knowing that the juror is a member of a particular group or has an affiliation with a particular group?
I believe there's room for an objection, but it's an objection to the ruling on the for-cause challenge. That's
So
where the
that
objection.
juror is forever insulated from any peremptory unless it's based, as you said earlier, on something like their, you know, mother also works for the BPD.
Exactly, because the peremptory has to be based on something that is personal and independent of the juror's group affiliation, racial affiliation. So if the juror, let's say, for instance, in the case I submitted, I don't know if you read it, the Kalila case, the juror said, my mother's a police officer, and that was good enough.
Let me ask you
For
this.
this court,
Would
not
your
for-
analysis,
not for that
would your analysis be different if the juror was white or black or something that was not Asian? If this were a white juror who gave all the same answers
For an Asian,
and just said, I have a bias toward Asians. I happen to really like Asians, and I have a bias toward them, and I might be more inclined to be, I might be more lenient toward Asian people. Even though I'm white, I might be more lenient toward Asian people. Would that change the analysis?
I believe it would, because there is no group affiliation between a white person and an Asian person. This is sympathy.
If the judge then finds that it was a genuine and adequate reason that has nothing to do with the juror's racial or ethnic affiliation, are you suggesting we would have to find then that the judge was in error in making that
No,
determination?
if the juror is white, I think that's a categorically different scenario. There is no racial affinity.
No, I'm saying if here the judge found that the peremptory was not based on the racial or ethnic affinity or identity, but more so on, I think identity and affinity are two different things, but a white person can have an affinity for a person of a different race.
Affiliation, I think,
Sure.
is
So if the judge found it's not part of the affiliation or the identity of the juror, but it's their affinity, you know, if it's a white person that says, yep, I'm really sensitive toward people of any other race, and I'd be more inclined to believe someone because they're of a particular race, and then they say, I guess I'd be fair. What do you do with that?
I think it's different because you have to look at this in context, and especially in the context of the Batson cases, which originated with discrimination against black jurors where the defendant was black, and it was based on suspicion that those African-American people would be more sympathetic towards a black defendant than other jurors would be. And that was specifically called out in Georgia versus McCollum, which said, you know, that is simply off the table. You know, any kind of assumptions based on implicit bias related to a juror's group affiliation are disallowed. It's inappropriate for a peremptory challenge.
I want to make sure that you have time to get to the money laundering arguments, because you're running out of time, and we've only talked about the juror so far. What do you want to focus us on with respect to those?
Okay, money laundering is absolutely no evidence of concealment in this case. So the theory...
How about sorry to interrupt you, I'm just trying to speed things along. How about the gift card messages?
Okay, so the Brown opinion is what controls here. The Brown opinion, 481 Mass 304. And Brown says that the concealment must be an animating purpose of the transaction. It can't be just an incidental attribute of the transaction. So the gift cards, I would argue, are incidental attributes of that transaction. I mean, the gift notes, like notes from Santa. Could be, I mean, you put a note from Santa on a gift, that has nothing to do with money laundering or tracing who actually gave that gift.
Well, but doesn't it though? I mean, isn't it designed to conceal? In other words, this is not from mom and dad. This is actually from an elf who came down the chimney last night.
But not. I mean, for financial purposes, that little gift note is not a transaction. The transaction is purchasing, using a credit card, buying the gift card. So the merchant who sells the gift card to you knows that it was purchased with that credit card. So the two endpoints of the transaction are the credit card company and the merchant who sells the gift card. And that's the transaction right there.
But take a drug case, for example, and I know we're over. I'm going to talk even faster. Just watch me. So if you get money in your heroin deal, right, you sell, I don't know, a key, you get a whole ton of cash, and then you go out and use cash to buy 15 cars for cash on, you know, used car lots, that's not concealment.
That's cash, and that's completely different from these well-documented online transactions. And that's something that goes both for the bank account concealment and the credit card concealment allegations. There's a huge difference between using cash and using credit cards, because credit cards are very well documented, well traceable, and I mean, you saw how, from the evidence, how easy it was for the police to trace all of this stuff from each vendor to the credit card, the exact amount, the date of purchase, and where it was being shipped to. It was being shipped to her address. So there was no evidence of an actual, that purchase of these gift cards and putting those little notes on them was the animating purpose of those transactions. The transactions were the credit card purposes, not the gift card, not the notes from Santa or from mom and dad.
Anything else? Thank you very much.
All right, thank you, Your Honor.
Good morning. May it please the Court. Assistant District Attorney Krista Elliott from Middlesex on behalf of the Commonwealth. I'll start briefly with the first issue that my brother started with. Here in this case, the trial judge properly exercised her discretion when she found that the Commonwealth's race-neutral explanation of its peremptory challenge of Juror 23 was adequate and genuine. Here, we need to be careful not to conflate the for-cause challenge with the peremptory challenge. They are two separate determinations. Once we get to the peremptory challenge, a judge only needs to make a determination as to whether a attorney's rationale is race neutral and whether or not that rationale is adequate and genuine. I think that my brother's case that he brought to this court's attention, Commonwealth v. Kalila, makes that point very clear. That case specifically notes that if there is an adequate and genuine reason for the challenge, it is fundamentally an abuse of discretion not to allow that challenge. And here the Commonwealth did present such a reason to the court, and the court did not abuse its discretion. Since Your Honors moved to the money laundering issues second, I will move there as well. Here, the Commonwealth presented sufficient evidence of money laundering where the evidence showed the defendant intended to conceal illegal tender through two different means. First, through bank deposits and subsequent money transfers, and second, through gift card purchases that included notes intended to make the gift cards look like gifts when those cards were purchased using the victim's stolen credit cards. There was certainly sufficient evidence by which a jury could find concealment money laundering in this case.
Can I circle you back just for a moment? I know we spent a lot of time on it already, but
Of course.
the defendant does argue, well, I'm not sure, in his brief, in her brief, I'm sorry, that the judge abused her discretion in finding an adequate and genuine basis based on the prosecutor adding to the objection that there was a concern about the juror being confused, and then the judge said, well, she's a PhD in biostatistics.
Yes.
What are we doing with that? And how does that fit into our analysis as to whether and to what extent the judge did abuse her discretion in making that determination?
Well, there are often situations where there are multiple reasons put forth, and I think that the judge in this case, that the record makes clear that the judge had made a determination that as to that first basis that had been fully fleshed out, there was an adequate and genuine basis for that peremptory challenge. The second basis, the court did not suss it out any further. She did not make any specific findings in regards to that secondary basis. And so it seems that it simply was not fleshed out. And I don't think that it goes toward whether or not the first basis was actually adequate or genuine. I think it was a separate basis that was not fully addressed by the court because there was an adequate and genuine basis.
The prosecutor seemed to argue that the juror seemed a little confused at the beginning of the questioning. Is there something in the transcript that you can point to that would suggest that there was any confusion there, any particular part of it?
Frankly, Your Honor, there is not. I am not entirely clear what was being referenced, whether it was something from the group veneer or impanelment, or whether it was something that simply does not translate into the transcript itself.
Thank you.
Turning back to the money laundering, I'll also note that the Commonwealth's financial expert properly explained how 3 examples of check deposits and subsequent money transfers that were drawn from the facts of the case could represent the process of money laundering. He did not testify to the ultimate issue of the defendant's guilt, and this testimony was proper.
Okay, but really? I mean, the caption of that exhibit is examples of money laundering. How is that not testifying to the ultimate issue?
I think that looking at that exhibit in the context of the testimony itself makes clear that the exhibit and the testimony was explicitly geared toward educating the jury on what money laundering, specifically layering, could look like. I certainly acknowledge that there may have been some better ways to caption that exhibit, but that exhibit did go in before the jury by agreement without objection. The defense attorney told the judge repeatedly that he was not objecting to either the testimony or the exhibit, and he explicitly told the judge that he did not feel that any of this evidence was undermining his defense. And so we're looking at whether or not the judge abused her discretion in allowing this evidence before the jury. And here, where the defense attorney repeatedly said he was not objecting, there simply was no abuse of discretion.
It started as a chalk, it seemed to me, although it didn't seem to spend a whole lot of time as a chalk.
I believe what really happened is that there had been an extensive sidebar conversation in which defense counsel had said, I don't object, I have no problem with this coming in. And then when the prosecutor started to present the evidence, she presented it as a chalk, assuming she was going to have to lay the evidentiary foundation in order to enter it in as an exhibit. And
The problem, if you get a chalk that says examples of money laundering, that's fine, but once it goes in as an exhibit, you probably ought to redact that part of it, no?
perhaps it could have been redacted. Again, it simply wasn't an issue. It was put before. The defense counsel did not object repeatedly. And so we're really looking at that abuse of discretion standard. And regardless, even if this was error in some capacity, there was no substantial risk of a miscarriage of justice here.
Well, why not? Because, I mean, in the 3 examples that are given are not examples that the Commonwealth is now calling out as supporting its theory of concealment money laundering, which is the only theory on which the Commonwealth tried this case. So how can we say there's no substantial risk where even if it wasn't an abuse of discretion to let this in, it teaches the jury, it instructs the jury, if you're looking for money laundering, look at these transactions. I think I said 3, maybe there are 4. But those aren't actually concealment transactions. Or did I get it wrong and you're saying they are actually concealment transactions? And if I did, that's okay, but please tell me why.
So I think the argument is that those would have been concealment transactions. So the Commonwealth proceeded on 2 separate theories in relation to money laundering. First was that these specific transactions represented concealment in and of themselves, that the defendant had taken multiple checks, had deposited them, had made staggered deposits, and then had, in fact, attempted to conceal some of that money by sending it to her family members, by sending it to one of her separate credit cards, thereby sending them to third parties for the purpose of concealment. The Commonwealth also proceeded.
So can I just pause you for a minute? When you say staggered deposits, are you talking about structuring? That, in other words, that it's concealment rather than just writing myself one check for $100,000. I'm going to write myself 20 checks for $5,000?
Yes, Your Honor, that's correct. So, and then the Commonwealth also proceeded on the theory that the gift cards, the gift card transactions were also concealment money laundering, with the specific evidence being that the notes that the defendant put on those gift cards were intended to conceal. So we proceeded on both theories.
But that second, the gift card thing is not part of the contested exhibit.
That is correct. There was no information in that contested exhibit related to the gift cards.
And I say contested, but it's just contested now. I understand it was not contested at trial.
Yes, that is correct. And I apologize if did I answer your question fully?
I'm not sure. I can't really remember my question.
Well, please feel free to come back to me if I didn't.
Can you take a moment just to address what I think is a novel and frankly an interesting argument about the elements of larceny and the sufficiency of evidence where she didn't have any money taken from her, technically speaking, and pretty much the way it works, right? If you get a credit card, part of the deal is you're not on the hook if someone uses your credit card to steal things. So it's really larceny from the bank or from the credit card company as opposed to the individual who happens to hold it when they're not ultimately responsible. What about that?
I frankly think it's a bit of a red herring. You know, we have systems in place specifically to avoid victims of crimes from having to be, victimized further by not being able to retrieve their money. It's very similar to our restitution process. I think, certainly there is this federal truth in lending piece where the federal government has essentially decided, yes, we're going to make sure that banks are not holding victims accountable, but that has nothing to do with the criminal code. That has nothing to do with the elements of our criminal offenses. It simply has to do with how do we make sure that a victim is whole on the back end.
She's properly then identified as the victim of this larceny, even though she was not permanently deprived of anything in this context, other than, I suppose, the card itself, which is of nominal value.
Yes, I certainly think that that's true. I mean, we have the elements of the defendant took and carried away the property valued at more than $250. We have, which she had a huge amount of property in her room. The property belonged to or was possessed by that person 60 plus. Certainly that money that was spent was, in fact, her money that would have been spent. The fact that it was later forgiven is of no moment. And the defendant had the specific intent to deprive her of that property permanently.
Do you think there's a difference between if taking money out of a bank account, like take an ATM card, well, that's taking my money, and I may or may not get that back from the bank. But if you take my credit card and you go on a spending spree, generally speaking, I'm covered. Is there a distinction legally between those two as to who is the properly identified victim?
Not based on our criminal law as it currently stands, no. I think certainly the outcome for the victim is potentially drastically different because, a credit card theft, the money that's stolen off the credit card does have those built-in protections, whereas the money, if it's stolen out of your bank account, may not. But our criminal code does not distinguish between the two. And then finally, just to the final issue, the trial judge in this case properly instructed the jury on specific intent to commit larceny, both during the initial charge and in response to the jury question. There was no error.
Can I ask you, sorry, I just want to circle back to the multiple deposits question under the money laundering. So both Braun and Villarini, the court talks about the significance of the separate transactions. Factually, though, in those cases, the money was all in one place at the same time. And so then the staggered deposits were significant, I think, in part because of that. Here, the money was coming in because of the defendant's choice, obviously, in a staggered way. Does that make a difference from your perspective legally?
I don't think so. The point is really looking at the purpose of the defendant's actions. And so regardless of where the money was, where the money started versus ended in terms of looking at those staggered deposits, I think you're still looking at the defendant's intent of staggering the deposits for purpose of concealing the full scope of the transactions.
And the concealment cases require, as one of you cited earlier, that it be an animating purpose. Does it matter at all if it was really badly done?
No, I don't think that we require somebody who is engaging in criminal acts to necessarily be a brilliant criminal mastermind in order to find them guilty of the offense. The fact that ultimately this defendant was caught and caught quite easily, I don't think is of any moment when determining her intent and her intent to conceal. And, fundamentally when we're looking at this question here, we're looking at whether or not there was sufficient evidence, that any trier of fact could find these elements. And based on all of the evidence that the Commonwealth put forth, we more than meet that floor standard. And that's really the standard that we're looking at here on appeal. We're not concerned with the fact that the defendant that there might have been more intelligent ways to go about committing these crimes. If there are no further questions from the panel, the Commonwealth would rest on its brief.
Thank you. Thank you
very
both
much.
for your excellent briefs. Thank you for your argument. The case is submitted. The third case on our list is Commonwealth versus Patrick Amara, 22P0962. And again, this matter is partially impounded. Whenever you're ready, counsel.
Thank you. Good morning. May it please the court, Kirsten O'Brien on behalf of Patrick Amara. As you know, we're here today. I'm asking this court to consider reversing the jury's convictions of Mr. Amara for 3 counts of rape on the basis that he received ineffective assistance of counsel and that failure prejudiced him at trial. As this court probably knows.
May I interrupt you just for one moment? Is our clock all set?
Oh.
Thank you. Go ahead. I'm sorry for the interruption.
I will just mention, although I think probably all of you know that this court has seen this case before. So this appeal started as a motion for new trial that was allowed on this same basis, and the Commonwealth appealed that allowance. This court, I won't say reversed, but suggested to the trial judge that he rethink his decision, and he did so to the defendant's detriment. So I do recognize that this issue has already been before this court, but I'm hoping today perhaps to answer any further questions or flesh it out a little more.
So I have a couple of technical evidentiary questions.
Yes.
So one of your arguments is that the second witness statement would affirm the defense theory and the defendant's statements that the sex was consensual at first. Under what evidentiary rule do you get that third, at least maybe fourth-hand hearsay in substantively?
So just so I understand your question, you're talking about the same argument the Commonwealth points out, which is that Mr. Odom's statements as they existed at trial are, in fact, hearsay.
Yes.
Yes, okay.
So how do they come in substantively and affirmatively as opposed to solely for impeachment?
I think they come in only through impeachment. I don't think they come in
So how would they affirm
substantively.
the defendant's statements in defense theory, which I think one of
So,
the things that you argue?
from the position of trial counsel, I think that the proper and effective way to deal with those statements would have been to begin with, the person who made the statements, Mr. Odom, did testify. He was on the stand. So certainly he could be asked, didn't you tell, the investigator or Ms. Landetta Burke, X, Y, and Z, that this,
So stop there.
yes.
Assuming for the moment another witness had not testified to the contrary, how is that not straight up hearsay, objection sustained? Next question.
Well, I'm talking like I'm the trial counsel. Trial counsel obviously can't put that statement into evidence, but certainly trial counsel has a good faith basis to inquire on cross-examination. And then.
But then that would have a limiting instruction from the judge, right? So that you can't consider that substantively, you can't consider it for the truth of what was contained in it. You can only consider it to the extent it may or may not undermine a statement that was previously made by the witness that was named, et cetera, right?
And then Mr. Odom either says, yes, I did tell them that, or Mr. Odom says no, or I don't remember, and he can be impeached or refreshed, but the actual document does not come into evidence.
So let's move on to impeachment. Do you agree that whether she was drinking or had a drink or before going to the bathroom or not is collateral?
Entirely. And I've always thought that, and I would just maintain today that throughout, we filed a number of briefs, we have a number of arguments in this case, it's gone on for a while, and I've never pressed that as something that I thought was particularly important. I think the Commonwealth has continued to bring it up.
Drinking part, not so much, so then it's really what you're focused on is that to the extent that Mr. Odom told investigators that his girlfriend told him, that the victim told him something,
Well,
with respect to the consensual beginning of the encounter, that might in some way undermine the Commonwealth theory. Is that it?
it absolutely undermines the Commonwealth theory, and it affirms the defendant's theory. So
Walk me through how you get it in. That's what I'm not seeing. If I'm sitting up as a trial judge and you've got Mr. Odom on the stand and you say, did you tell an investigator or did you tell the UMass board that your girlfriend told you that the victim told her something which may or may not be inconsistent with what her testimony was, how is that possibly coming in?
I believe trial counsel can cross-examine him. It's hearsay, but that doesn't mean, there's still a good faith basis to inquire of him about it. It means the actual document doesn't come in because it's hearsay. But trial counsel can still inquire as to whether he made the statement. And then the jury, at least, for the defendant's purposes, if he says no.
So it would come in to impeach him. That's what you're saying, to impeach Mr. Odom's credibility.
Yes. Or he might say, yeah, that's exactly what I told them. I don't know. What Odom would have said had that question been posed, and obviously I maintain that it should have been, is at this point I would agree speculative, because we don't know. But certainly there were grounds to believe this, because we have the report. Again, it's hearsay, but there's a good faith basis to believe that he may have agreed with that. He would have said, yes, that's what I told him.
Do you agree with the Colonel's argument that if in fact you got that in, and I still am not seeing it, but if assuming for the moment you did, and the trial judge let trial counsel ask that question, that under the doctrine of verbal completeness, you'd also get in that, yeah, they also said that she said no, no, no several times?
Yes.
Okay.
But, and again, I recognize that may, in and of itself, if you believe that at some point she said no, that could establish rape. But I think the problem here, and this is taking the more bird's eye view of the case, is that this was a strong case for the Commonwealth, and there was very little evidence to support the defendant's theory of the case. The defendant, trial counsel opened with the theory of the case that this is a story, I think, forgive me if I'm this is a story about sex and regret, or a hookup and regret. And there really was nothing to support that. This statement, Odom's statement, which wasn't just from his girlfriend, by the way, the statement that he gave, that he heard from his girlfriend, the girlfriend was the first complaint witness also.
So again, and I'll lay off this and I'll let
No,
someone
it's
ask a
okay.
question, but so again then, for it to be of any, for it to have any meaning,
Yes.
then that statement that Odom allegedly gave to the UMass committee and to the police department would have to come in substantively for the truth of it, for it to have any impact on supporting the defense theory, as opposed to simply saying, well, Odom's not very believable.
I disagree, Judge, only to the effect that I think that Odom could be cross-examined on that and impeached, and I think that it could also be used to inquire on cross-examination of the first complaint witness as to whether that's what she told. Oh, I mean, these people testified about these things, and so I think they can be cross-examined on it.
Right, but we circle back to, again, what the limited purpose is for that testimony, which, again, at least as I understand the rules of evidence, would be for impeachment only and not for substance, for the jurors to assess the credibility of the witness who was testifying and not for the truth of the statement that was made out of court at a prior time, right?
And if that's true, I think that would still have been substantially helpful to the defendant's case, because it very much changes the lens through which this incident was presented by the Commonwealth. This was presented as, I would say, a violent attack on the victim, and those statements change very much that lens, that this was something that began consensually, and then one party may have decided she was no longer interested in continuing it. So I just think it's a very different perspective on the case.
But that's still rape.
If the jury believes, yes, it could absolutely establish rape. It's hard to know, again, because the case didn't go in this direction, whether the jury would have, I think the jury would have had to hear evidence of withdrawal of consent and would have had to credit that withdrawal of consent. So I think a lot of this is somewhat speculative, and we don't know how this would have played out because it wasn't used. It wasn't, and I will say that there were two separate trial counsel's affidavit stated that he did not remember ever seeing these documents or seeing these statements whatsoever. It was
But
either.
he also, I'm sorry.
Oh, no, that's fine.
He also, if I'm remembering this correctly, which I hope I am, then agreed that they were in his file.
Prior to the hearing on the motion for new trial, he said that he did go back and look in his record and saw them. And because they were there, believed he must have read them, but still didn't recall. So I think whether he read them and chose not to discuss them with the defendant and chose not to think about and chose not to use them, which I maintain he could have, or didn't read them at all and failed to see them, I think given what he had before him to use at trial, either way, it was a prejudicial failure. Okay, if there's no further questions, I'll rest on the brief.
Thank you.
Thank you.
Good morning, Your Honors. May it please the Court, Cynthia Von Flatern, Assistant District Attorney for the Commonwealth. The Commonwealth would submit that the evidence at the motion for new trial showed that defense counsel did in fact have these statements. They were in his jury file under the witness's name. It would also show that he did not recall sharing the information with the defendant. And the evidence would show that they would not have been particularly helpful for the defendant. As this Court has pointed out, and as the Commonwealth pointed out, they could only be used, they were at least third-level hearsay, could have been used to cross-examine Mr. Odom, who may have said, yes, that he did say this to the UMass investigators, or he may have said, no, that's not what he recalled. So that actually was a fourth level of hearsay, because this was Mr. Odom's statement to the UMass investigators. They would not have been available to cross-examine the witness on, or the victim on, because it wasn't what she had, there was no difference between what she had said to the first complaint witness and what he said. What Mr. Odom, what the investigators had said was Mr. Odom said that his girlfriend, who was the first complaint witness, said that the victim and the defendant had been drinking, they were having sex, and then she said no, and he wouldn't stop, and she kept saying no. The statement to the Hadley police was the same as the UMass investigators in the sense that it said that the victim and the defendant had been drinking, but it never said that this started consensually. It only said that she kept saying no. She said no. I think that the issue about whether the victim had been drinking was important to the trial judge originally, because the defendant's theory of the case was that there was a sexual encounter, and then that the next day there was regret. And if the victim had been drinking, that would have helped that theory. But there was absolutely no evidence that the victim had been drinking. And I think if Mr. Odom's statement had come out, it would have shown to have very little weight.
Is the video part of the record on the prior appeal? Was the whatever she had uploaded either to Instagram, or said she was playing music or singing or something just
Yes.
before she went?
Her
I didn't
photo-
see it here, but is there a photo or
There
a
is
video?
there is a photo, Your Honor, in the trial exhibits that show her playing her guitar before she goes to the party. And her testimony was very clear that she had been doing her homework, went to the party not till 9 o'clock, whereas the defendant had come at 6 and started drinking.
That's a photo. It's not a video. We can't see
It's not a video.
her demeanor other than
Right.
still.
It shows somebody that's doesn't look drunk in the picture, but it is only a picture, not a video. It was also probative because one of the defense witnesses said that she had opened the door to the bathroom and she had a pink sweatshirt on, which was her sorority sweatshirt, and she did not. She had a dress on. So the defense theory was that this was a consensual encounter, but as the defendant acknowledges, the evidence of that was very weak. In evidence in the Commonwealth's case was the defendant's recorded statement to the UMass officials. And his statement is that the victim accompanied him to the bathroom because he was drunk and was trying to help. That was always, all the evidence showed that. And he told the UMass investigators that she stepped in front of him, and that he took that as meaning that she wanted to have sex with him, and then that's when the encounter occurred. So it was, I think, a pretty weak theory to begin with, and then you had the testimony from the victim, which I would submit the jury found credible, and then you also had the first complaint testimony. Mr. Odom also, the reason that he was even called as a witness was he went to the party with the first complaint witness and then saw the defendant later in the evening, after the encounter and after the victim had started drinking, and she had testified that she explained after this happened, that's when she wanted to wipe out what happened and started drinking. Well, then the defendant followed her into a second bathroom, and Mr. Odom interrupted that, so that's why he was testifying to begin with, not because he had any evidence to submit with respect to what this first complaint witness had told him. If there are no further questions, the Commonwealth would address. Thank you.
Thank you both very much for your briefing and careful arguments. The case is submitted. Our fourth case today is Jennifer Gasek versus Mary C. Foley and others, 2023 P0532. Counsel, whenever you're ready.
Good morning, Your Honors. My name is Attorney Lauren Galvin, and I represent the Foley parties in this matter. The Foleys live on a beautiful pond in Drake, Massachusetts, and they have lived in their home peacefully since 1993, almost 30 years. Mrs. Gasek moved in 2018, and 1 year after she moved in, she sued the Foleys, filing 7 counts against them. The lower court denied 5 of the 7 counts at trial, and Mrs. Gasek did not appeal that decision. It was inconsistent for the lower court to allow the claim for trespass and encroachments and the related injunction, but to deny the other claims for trespass. It didn't make much sense. The Foleys had had to defend against this litigation since 2018, and it has caused them great harm. If the court allows the boundary line determined in the lower court's decision to stand, and I'd like to direct your attention to the plan, our expert's plan at Addendum 61. It's the best place to find it. It shows on this plan that there's the right-of-way which runs down to Long Pond. That is not actually that is where the right-of-way would be located based on the deeds, but on the actual ground, that is not where the right-of-way is. You can see on the Foley's property where the 2 sheds are located and their home is located. You can see the red line, which was the boundary line determined by our expert, and the blue line, which was the boundary line determined by others in this matter. There's a nail that's shown on that blue line, and that's the blue line that was determined as the boundary of the court.
Could I interrupt you and ask a question? If I understand your argument correctly, part of it is that an expert is required to prove the boundaries of a lot as a general matter. Is that correct? Is that your argument?
That is correct, yes.
Doesn't the case law say something very different than that, that the judge may consider a variety of different types of evidence in making that determination?
Yes, but as a threshold matter, you would need an expert who had done a survey to show the boundary on the ground. They didn't even put any expert on the stand to demonstrate that boundary, and you cannot rely, it was error for the court to allow the other side to use our expert to establish that boundary. That is not allowed under Massachusetts case law. Actually, I wanted to give the court a cite on that. There's several Supreme Judicial Court cases on this matter that when you have the opportunity to obtain your own expert, and they had their opportunity here, they actually listed him in the pretrial memorandum, and then for whatever reason they did not put him on the stand. They cannot use our expert to establish their case and their burden of proof. And I just wanted to give you a case.
The case, that'd be a remarkable principle of law.
Yeah.
To me. What's the case?
It's 341 Mass 377, 1960. Ramacordi versus Boston Redevelopment.
So if you put your expert up, they cross-examine your expert, they get everything they need from your expert, he concedes whatever it is that they want to get in the record. You're saying that they're still required to pay an expert to come in and testify?
Well, they didn't get everything.
No, I'm just saying in
they
theory,
needed.
based on the principle you've just articulated, which doesn't make a whole lot of sense to me.
Well, they had the burden of proof in this case, so it would be unfair for them to use our expert, who's on the stand giving an opinion on our case, to support that. It just doesn't. There's a disconnect there. There was no and you could say they relied on deeds that were in the record, but you need to somehow tie the deed to the land, and that's where you need a surveyor.
Doesn't your expert's map, the one you just pointed us to in the addendum, tie those other deeds to the land? In other words, looking at the addendum page you just cited me to, us,
Yes.
it wasn't just me.
Could you give the page again? I'm sorry. I just,
Oh, yeah, it's addendum page 61.
Thank you.
So there's this line determined by others, that's a blue line that, if my old eyes are not deceiving me, leads directly through the middle of a shed and along the edge of the disputed deck. Doesn't that piece of evidence establish that if the lot line determined by others is correct, your client's shed and deck encroach over the other side of it?
He was showing where he was just taking the other plan, which was the Norse plan, which was their plan. That was a plot plan that was not used to establish the boundary, but he was just showing where that line would be located. And he was showing that line, and then he was showing the line that he thought would be the most logical line based on all of the evidence, and that was the red line.
So he went out and looked at where the things were
Yes.
on the ground,
Yes,
and then determined that if these things are actually on the Foley property, this is where the line should be.
the red line is where the line should be, and he gives ample testimony about that.
And what relationship does that have to, for example, the 1970 plan that is filed in the assessor's office?
I think the 1970s, do you know which plan that was? I have the plans.
Oh, I
right
don't
here.
know, there are a lot of them, but I can find it probably.
I have them all right here.
Yes, it's in Record Appendix Volume 2 at page 11.
Okay, thank you.
Sure.
Oh, yes, I know the plan. So this was the plan that started it all. This was the plan that's referenced in the Foley's deed. And yes, he uses, so there's one,
Sorry, who's he? I just want to make sure I'm following.
our expert, Helms, when he created his plan, that shows the red line, what he did was the only thing that he had was the deed, and, the starting point was the deed, which references this plan that you're discussing in the record. And in that plan is the fence corner. That's the marker. So that is the marker that he uses on his plan down by Long Pond. And he says, old fence post cut. And that is the marker he uses to begin his survey, and then brings the red line straight up. So yes, that was the marker he was using from that plan. That's how that relates. So he took this plan, which is the plan that established the Foley's lot, because the deed says, as referenced in the plan that you're talking about. And then he went to the ground and he used that plan and the deeds and other deeds. He did quite a bit of title research, and he said, based upon all the research and the other research in the area, the boundary line that makes the most sense based upon all the evidence is the red line.
And that was his opinion.
That's correct. And that was the only expert opinion in the whole trial.
And the judge was bound to that opinion. Why?
Because it was the only expert opinion in the trial, and there was no other evidence that could lead him to a different conclusion.
Did he reject that evidence, though?
The judge relied on the Norse plan and kept calling it a survey plan, but it was not a survey plan. And I would like to point out that the certification on the Norse plan specifically says, so plans can be purchased for different reasons. A survey plan is going to be more expensive than a plot plan because...
Was that issue raised at all to the trial judge? I just don't recall.
It was, yes.
That the other surveys were unreliable and should not be admitted into evidence?
Correct, yes, and that was in
Where
the
was that?
findings of fact and the proposed findings of fact by the defendants.
Where in the trial record was that objection?
Oh, sure, that's in the trial record. That is at volume 1, page 46. Is the proposed findings of fact?
No, I'm saying where in
Oh.
when the trial was going on, at some point, did counsel for the Foleys say, for example, Judge, you can't, I object to the introduction of these surveys, or these surveys are not reliable, they're not admissible in evidence, you can't base your decision on the Norse survey or anything other than Mr. Helms's
He did not object in the trial, but he did put that in his proposed findings of fact and rulings of law.
Okay, but if that wasn't raised at trial, why is that issue not waived?
Because there just simply was no, this is a case where the plaintiff had the burden of proof, and they had to prove by a preponderance of the evidence. And what I'm saying is there was no evidence. There was, like, if you look at the actual evidence that the judge relied on, this Norse plan, it says, I certify that the structures shown above lie entirely within the lot lines as shown. That's all this plan is certifying to, that the structures, a survey plan certification is our surveyor's plan, the Helms plan. That certification says, I certify to the best of my professional knowledge, information, and belief that the survey and plan conforms to the, he's saying the word survey, ethical, procedural, and technical standards for the practice of land surveying in the Commonwealth of Massachusetts. That's the stamp and certification you use when it's a survey plan. When you're doing a quick sort of plot plan or a mortgage plan, this plan was created not to establish the boundary, but for a Concom filing on the...
So understanding that to be the case, why is it still, and maybe there are different ways of weighing that evidence, assuming that these are all in evidence, as I understand that they were in this particular case, but why is something like the statement in Paul versus Kelly that says when a boundary line is in controversy, it's a question of fact on all of the evidence, including the various surveys and plans where the true line originally ran? So why is that not more inclusive than saying it must be only a particular survey certified in a particular way? That's not what I at least see in the case law.
Because the Norse plan was not a plan that was being used to establish the boundary. The Norse plan was just showing, that was actually only a plan of Mrs. Gasek's lot, and it was only showing that her structures were on her property. That's all it's certifying to. The fact that surveyors will tell you when they go out there, they could be off by a couple of feet. And when there's different surveys and different certifications, and this piece of evidence was not certified that it was a survey of the boundary line.
So let me ask this, only because time is getting short.
Yes.
I think your argument is also that the judge improperly relied only on the Norse plan. Is that part of your argument?
Yes, and the other plans, I mean, it's the same theory. He's saying he relies on the Aho plan and the Damaris plans. None of these are survey plans. They're plot plans, mortgage inspection plans. The only survey plan in the case is the Helms plan.
Okay.
And I just wanted to make one quick point about the, we were talking about the marker and the fence post. And that was an issue in the trial that after Mrs. Gasek filed this lawsuit, the Foleys hired Mr. Helms to go out and conduct a survey. And he put an orange sticker on the post, as surveyors do. And she came home the next day from a wedding or something, and she saw the orange post, and orange sticker on the post, and she cut down the post that was used, that Mr. Helms was using. She knew what he was doing and what it was for.
Was there a motion at that time based on spoliation for the judge to take any particular action?
There was no motion, but I did want to cite to the portions of the record where I think this issue was preserved, and it was in both the proposed findings of fact and rulings of law, and that's at volume 1, A00046, paragraph 12, the defendant's proposed findings of fact, and volume 1, page 49, paragraph 10, defendant's proposed rulings of law, and also it was in Gasek's trial testimony. So
Not that it maybe matters, but was there any prejudice alleged as a result of that being taken down? My reading of the transcript was that Mr. Helms was still able to complete his survey. Is that true?
That's right, but the case law there is quite a bit of case law about when you take such action in the middle of a court case, and particularly with markers. Those have special status under our law. So I
Circle back one for a moment. I just read, and I'll be it quickly, Ramacordy versus Boston Redevelopment Authority, the case on the expert.
Yes.
And as I read it, so the petitioner hires a couple experts, calls one of them, and then the respondent wants to pay a statutory witness fee and put the petitioner's other witness on the stand, and the court says, well, it's not an abuse of discretion for the judge to say, no, you can't do that. How does that, doesn't that mean that it's up to the judge, and the judge has the discretion then to permit the witness to testify and for the other party to use the witness's information. Why is that precluded as opposed to within the judge's discretion?
I think here it was an error because clearly they had designated their expert and we had designated our expert, and then at the last minute at the trial, suddenly they're not calling their witness and they're calling our witness. I think under that case law and other SJC.
But are you suggesting
case
the
law.
judge did not have discretion to permit that as opposed to a hard and fast rule that you just can't do that?
I don't think he had discretion, no.
And you said they're calling our witness.
Yes,
Did they actually call the witness as
Yes.
opposed to cross-examining?
correct. Yes, he was the first witness that the plaintiff put on in the trial.
Okay.
Thank you.
Thank you very much. Good morning.
Good morning, Your Honors. May it please the Court, Douglas Hausler representing Ms. Gasek. The Court just spent 15 minutes focusing on this blue-red line plan issue, so let me try to address it because I was trial counsel for Ms. Gasek. I purposely put Helms on the stand first for the exact reason that Mr. Justice Brennan has identified, which was I got everything I needed out of that expert. I had Mr. Helms first testify because he said he did extensive title research, plan research at the Registry of Deeds and through the Registry of Deeds, and actually did the survey. His plan is stamped. I don't disagree that his plan is admissible. We agreed. We stipulated to it. But the defendants stipulated to the admission of every deed of the Foley chain of title, every deed to the GACEK chain of title, stipulated to the Damaris plan going in, the AHO plan going in, the Norse plan going in, none of which are survey plans.
They didn't object to you calling their expert?
Not once. And I might add, Your Honor, that if in fact they wanted to try to impeach my client's case or challenge it, they had every right to call my expert if they wanted to. They could have subpoenaed that person and have them come in, but they didn't. So that issue, at least, I thought was waived. I got everything I needed from an expert, designated and approved by the court, admitted to be an expert by the defendants, and I was able to get him to admit that, A, if the blue line was correct, that was a feasible, it was absolutely true that the property encroachments that I identified on the Norse plan were accurate. So that was one of the first things I got after getting all the chains of title and all the deeds. The second thing I went after him about was, had he found any discrepancies in his chains of title to where there were a challenge to the lines from anybody? And he said no, admitted such in the trial record. He further said that on the Helms plan, that if the trial court adopted the blue line, that it would be accurate for the court to do so. So it was the court's discretion. There are two possibilities under the testimony of Mr. Helms, a red line or a blue line. And based on all of the evidence submitted at trial, without objection, the court made specific findings and rulings that the blue line was the much more credible plan and relied on that. The second argument that one of the counsels made this morning was that the trial court was relying on the Norse plan. That's not accurate because the record states in the decision on, the trial court's decision on page 8, it says, based on the Helms plan and the Norse plan. Again, the trial judge did exactly what I was doing, which is we were relying on the Helms plan. So it had competent evidence, it had competent testimony, and it had all the plans of records and deeds of records. So I don't think there's a real issue here about the correct line being applied. What was not addressed in argument so far was that the Helms plan was only prepared after litigation was commenced. He was a hired gun. He prepared the plan that best suited his clients. And he covered his opinions so that he would not be accused of falsely certifying things by saying, line determined by others. That's just hedging your bets. And that was the fact that I seized upon to try to demonstrate that this was just purely a hired gun expert, that he was trying to basically mislead by that plan, that the red line, he had some crazy notion that it wasn't the center line. Every deed in the Foley chain of title used the center line of the private right-of-way.
Except one, was there one that omitted reference to that
The
right-of-way?
AHO plan, I think. But the deeds were consistent, Your Honor. Helms admitted that his own red line could be off. He acknowledged that in his trial, and the trial court found that way as well. So overall, the trial court made extensive, specific findings of fact, and then took those and applied the correct law, because I think we've cited the case law on this properly, that we met the burden of proof required to establish the boundary line. So then we go to the issue of whether they should be removed or not, which they spend some time in their brief, whether it's, quote, de minimis or not, which was not addressed in the oral argument. These are not de minimis encroachments, and the case law clearly supports that de minimis encroachments are incredibly exceptional and rare. I've cited the long-standing Massachusetts precedent that where the courts don't sanction essentially private eminent domain. And that's exactly what happened here. To further undercut their request for this court to overturn the trial court's determinations about whether something was de minimis or not, they failed to address a very important criteria. It's not just the fact that they didn't put in any evidence of the damages that would be incurred, the out-of-pocket costs that would be incurred by the defendants to remove these items. No evidence submitted on that whatsoever. But they also never addressed that all of these encroachments were done intentionally. These are not unintentional. And the reason that I can support that in the record is because the trial court found that Mr. Foley had no specific testimony whatsoever to say, we applied for permits, we submitted things to the building department, we got plans before we did the work. The court clearly identified in the testimony of Mr. Foley, he had no specific dates, he had no invoices, he didn't even have quotes for doing the work. He had zero evidence.
How does that lead to intentional as opposed to, say, negligent or DIY?
Because with respect to for example, the stairway, which is on the side facing Ms. Gasek's house as well, they prepared that, the AHO plan was prepared specifically to go before the town to request permission, and it was rejected by the town because it violated the side yard setbacks. Yet it got created, yet it was built.
Well, but I mean,
that's intentional, Your Honor.
well, there's a step from intentionally not getting a permit to intentionally going onto your neighbor's land. I mean, you say side yard setback, I don't know what it is in the town, but let's say it's 5 feet or 7 feet, you can put a stairway that goes into the setback that doesn't cross the property line. I'm assuming there's a stairway off a deck, so it's like 5 or 6
It's
steps.
off the side of the house that leads to the deck. What they did is they flip-flopped the stairway because that suited their purpose. The other admissions that I introduced into the record at trial, Your Honor, is the extensive work that was done by the Foleys without Conservation Commission permission. They created a tiered backyard, moving substantial amount of ground.
Okay, well, but so that could make them maybe scofflaws in some way, but I don't think that that bears at all on where the property line is. Where am I missing the connection there?
It's a consistent pattern of disregard for the zoning bylaws of the town of Drake that was established at trial. And they knew enough to get a plan done before they built the stairway. So they knew that they had to meet certain requirements. They were told they didn't meet those requirements, and yet they went forward and did it. And they did it on the basis of a non-survey plan. They did it on the basis of the AHO plan, which they're now saying can't rely on it, or we couldn't rely on it, but they could to build encroachments. That's inconsistent.
Well, it sounds like they didn't rely on it to build encroachments.
Well, they apparently relied on it enough to take the leap of faith to go forward and build the stairway, which is substantially encroaching by, not an inch or 2 or 3 inches. It's 1.4 feet. The other encroachments, 3.3 feet, 3.5 feet, 4 feet, 4.5 feet. All of these encroachments that the court found, these weren't de minimis. The trial court cited one of the cases, and I can't recall at the top of my head, Your Honors, but where the alleged de minimis encroachment was something like 13 inches. And the court said, no, it's not de minimis. 13 inches is, in fact, significant. And when you take that factor, plus the fact that, as I've argued at trial and now before this court, that it was clear that they gave absolute no real consideration of the zoning bylaws and requirements before doing these things. I think that makes the finding even worse, because it's clearly, I think, doesn't satisfy being unintentional. So we have the intentional argument, as well as the fact that it's private eminent domain, and the fact that there was no evidence submitted at trial about the cost to remove.
Counsel, could I ask a slightly different question? Is there anything in the judge's opinion, as far as you're concerned, that impacts the accessibility of the right-of-way or the validity of the right-of-way?
Their inability to use the right-of-way based on the court's ruling is because they put up a structure themselves that prohibits them from gaining access to their own property.
Which is what?
It's some large, I'm going to say boulder, that's in the middle almost of a driveway access way in. These houses are very close together. They're on the lake. There's no question they're close. And then it's a family situation as well. The Foleys, if I may use my hands here for argument, but the Foleys live here, GACEK lives here. Foley's father lives here, owns property here. She's surrounded by Foleys, my client, and/or friends of the Foleys. And what they've done is they just want to keep using her land to get in. And why are they using her land? Because they have trucks and other cars that they were operating a business there, which the trial court said that's for us to go to the town of Drake and argue that point out. But we established quite a bit of evidence there as well, Your Honors, that they were using this for commercial purposes. Again, in violation of law, but we'll deal with the town of Drake on that after this case is decided. With respect to the adverse possession issue that they've raised in their brief, the claim was the trial court properly found that the elements of adverse possession were not met. In that regard, the judge made specific findings that there were no specific dates submitted by the testimony of Michael Foley, and he was the only person called to testify as to that issue. Notably, trial counsel for the Foleys did not call Mary Foley, who is who I expected would be the one to testify as to the specifics, because she apparently was the one who was supposedly going to the town or interfacing with town officials. Yet, they never called her. And that was to my benefit as well, which is just trial strategy, quite frankly. The trial court found that there were just generalized statements being offered by Mr. Foley. No specific dates, just these things took place, all these changes took place between 1998 and 1999, remarkably just outside the 20-year limit. But no facts, no dates, not even a month, no invoices, nothing, not a permit, an application to do work, nothing. There was a complete lack of meeting their burden of proof to establish adverse possession. And I think the trial court's rulings were specific enough on that they should be affirmed by this court. And last that I'd like to address in my limited time is this issue of the cutting down of the marker or post. This was never raised in direct or cross-examination that I'm aware of, Your Honors. There's certainly no motion for sanctions brought in the trial court level. As far as I was considering, I would consider it waived for the reasons I identified in the brief. Never even mentioned, and mentioning it in a findings of fact and rulings of law when there's no real direct testimony on that in the record, and none that was cited that I could find by the Foley's counsel in the record. I don't believe that they can make any such request to this court to say, not only throw out the entire rulings of the trial court after 3 days of trial, and on top of this, the trial court took a view of the property. It was extraordinary. And trial counsel and I got along fine. The judge and the clerk, we went there, they walked the property. The trial court had a very, very clear understanding of what was taking place. And the record showed that, and the decision showed it. And I believe it should be affirmed on all of the bases that we've set forth in the brief. Unless there are other questions, I'll cease.
Thank you. Thank you both
Thank you
for your briefing.
time.
Thank you for your argument. The case is submitted. We're going to take our mid-morning break for about 15 to 20 minutes, and then we will pick up with case number 5.
All rise.
Thank you. Good morning. Our fifth case today is Linda S. Rory and others versus Axe Equitable Life Insurance Company and others, 22P1128. Attorney Hort. And you have a request that you have your client sit with you, is that correct?
I'm sorry, Your Honor.
Did you ask that your client be permitted to sit with you?
Oh, that's okay.
She may, if you'd like her to.
Get down here and get that.
And my understanding is that there may be a vision issue for you. Is there any way in which we can accommodate you to make this argument work more smoothly? For example, would you like to be alerted when the lights change on the timing device?
I'm sorry, Your Honor. I'm having trouble hearing you.
Sure. Is that better? Are you able to hear me, counsel?
Yes.
My question to you was, is there any way in which we can accommodate you during this argument? For example, would you like to be made aware when the timing lights go off to indicate the wrap-up time for your argument today?
Yeah, if I could be told when I'm down to 4 minutes and 2 minutes, that'd be wonderful.
Yes. I will do that, and then whenever you are ready,
Okay.
go right ahead.
Stephen Hort, Your Honor, appearing for the appellant Linda Rory, who's the personal representative of the estate of her deceased husband, Edward McLean. One of the overarching issues in this case is the fact that the change of beneficiary form under which the appellees may claim never became effective. In August of 2019, Linda filed a motion for summary judgment on the grounds that the COB never became effective because Neil McLean purported to submit it to the insurer after Edward McLean had died and after Neil McLean knew he had died. And when we provided a series of Massachusetts cases, including this court's case in Kelly v. Nielsen, Note 3, a 2000 case, to the effect that an agent's authority expires when the principal dies, or in the case of a holder of a POA, when the POA holder becomes aware they died. And Linda's summary judgment evidence was uncontroverted. Attorney Fanger, counsel for the appellees, conceded at oral argument that there was not a sufficient delivery, and the probate judge made findings and conclusions to the effect that the COB never became effective due to the lack of a valid delivery. But the probate judge nonetheless denied the motion for summary judgment on the grounds that Linda, as PR, lacked standing to make the motion. So let's talk about Linda's standing. Under Massachusetts law, the PR has broad authority to bring claims on behalf of a decedent's estate. That authority is codified in the Uniform Probate Code 190B, Section 3703C, which says that the POR, or the PR, the personal representative, steps into the shoes of the decedent and can bring any claim that the decedent can bring that survived the decedent's death. And in Slisky v. Crow, the Supreme Judicial Court said that the estate representative always has standing to bring a claim founded in contract, including claims that first arise founded in contract that first arrived after the decedent's death. And the case of Betancourt v. Betancourt is to the same effect. That case involved a reciprocal wills. The surviving spouse no longer wanted to comply, and the beneficiaries of the decedent spouse wanted to sue, and the Supreme Judicial Court said no, the person who should sue is the PR of the decedent's estate. And in this case, Linda's standing is founded on three very distinct contracts. The first is a 2005 policy of insurance. She can sue to enforce the policy, and that was made clear in the case of Tyler versus Treasurer and Receiver General. In Tyler, the court started out an opinion which talked mostly about the beneficiaries' rights, because that was what was at issue, is that a state representative always has standing to sue on an insurance policy, but the holding in Tyler goes far beyond that, because in Tyler, the plaintiffs were estate representatives, and they were suing to protect the rights of the beneficiary against the taxman. They were looking for an abatement of taxes being assessed under the insurance policies, and the Supreme Judicial Court granted them relief. The second...
Counsel, can I ask you a quick question? And I'm sure I'm oversimplifying this, but so the personal representative steps into the shoes of the decedent, right? I'm with you there. What interest does a decedent, once dead, have in a life insurance policy?
I'm sorry, Your Honor.
Sure. What interest does a decedent who is dead have in the proceeds of a life insurance policy?
Well, Your Honor, if you look back at Massachusetts law, there's a long distinction. The case isn't cited in my brief, but it's the Penske case that goes back to 1865 that talks about the decedent, the insured, holds the legal interest and the beneficiary holds the beneficial interest. And we're talking about standing here, and the insured has the right to both enforce the policy, for that matter, change the beneficiary into the policy, but also to challenge people who are seeking to make claims to the policy. That gets to the third
Can I just ask you, your client was never named as a beneficiary of the policy, though, correct?
Ms. Rory was never named as a beneficiary on the policy, but she is the default beneficiary under the policy, and under Edward McLean's will, she's the sole primary beneficiary and residual beneficiary of all financial assets. So if the original beneficiary had predeceased Edward, it would have passed Linda under the will. And
It would have passed, though, if I may just clarify that, it would have, Ms. Rory is the residual beneficiary in her personal capacity, correct?
Yeah, she's both the personal representative, and she was a beneficiary of virtually all assets other than some carpenter tools, which were devised to Scott.
Right, and we're talking here about standing, and I've looked at the various complaints, and in each of them, it's very clear that Ms. Rory is bringing the claims in her capacity as personal representative of the estate. So I don't, I just want to clarify that you're not arguing today that her status as a residual beneficiary under the terms of the policy gives her standing to bring the case that she brought as a personal representative.
That's correct.
Okay, thank you.
Yeah, the residual beneficiary, or the argument of the default beneficiary, comes in a different way. The second contract that Ms. Roy has standing under is the power of attorney that Neil McLean received from Edward McLean 9 weeks before Edward's death. And this court in Gagnon versus Coombs held that the holder of a power of attorney had fiduciary obligations and rescinded a transaction that the POA had entered into. And Linda steps into the shoes of her decedent husband and can hold accountable the breaches of fiduciary duty that occurred and seek to rescind transactions that were entered into as a consequence. And the final one is the change of beneficiary itself. And that is the contract that the appellees would say existed between Edward McLean and the new beneficiary, supplanting the old beneficiary. And under Slisky v. Kroll, Linda has contract claims which she gets from her husband, that the COB never became effective due to the fact that there was never a valid delivery. So the standing issue should not have been an impediment to the grant of Linda's motion for summary judgment, and the case should have ended then, but that's not how it ended. Well, what happened instead is the probate judge adjudicated a cross-claim that appellees filed 8 months after Linda's summary judgment motion, that contended both that the COB was valid and that they received the benefit of the 33% interest under the change of beneficiary form that Neil McLean forfeited in his bankruptcy. And the probate judge made many, many errors in the process of that ruling, but at the end of the day, concluding that the interest of Neil McLean was a joint interest with Jean and Scott, and it reverted to Jean and Scott, and that as a consequence, Linda did not have standing. Now, if one is going to look at standing from the perspective of Neil McLean's interest, the probate judge got it wrong. First off, the probate judge decided, without giving reasons, that the interests under the policy, whatever they were all converted into joint interests. And that ignores the actual language of the change of beneficiary form, where Neil's interest is designated as a 33% interest, not a joint interest. And secondly, it ignores the language in the policy itself, which indicates that AXA, the insurer, follows whatever direction is being provided by the insured. And Attorney Fanger replicates that error at page 13 of Apley's brief, where Attorney Fanger quotes from the AXA policy but deletes the words "unless you direct otherwise." And that illustrates the error in the probate judge's reasoning. It's clear error in construing a contract, including an insurance policy. The court is to endeavor to give meaning to every word and phrase and not to pick and choose among the language. Secondly, even under the AXA policy, if it starts out as a joint interest and ends up as a separate interest on the death of Edward, which happened in 2013. And that's because on Edward's death, all joint interests are portioned so that whatever the death benefit is, it's apportioned equally among the survivors. The probate judge walked around that by saying that Neil McLean's 30% interest was going to be treated as if Neil had not survived Edward. So what the probate judge did, in the context of a paper record rendering summary judgment against Linda, in which Linda is entitled to the benefit of all favorable inferences, deliberately disregarded the fact that Neil McLean did not predecease Edward. In fact, he was still alive in 2019 when he entered into the bankruptcy settlement.
Counsel, excuse me for interrupting me. You have 4 minutes left.
I'm sorry?
Excuse me for interrupting me, but you have 4 minutes left.
I'm sorry, I have this head cold and I can't hear anything, Your Honor.
Sorry, there are 4 minutes left in your argument time.
Oh, thank you. So I've covered those problems in the brief. Attorney Fanger mentions that, well, I'm going to go down to the jurisdiction issues then, Your Honor, because what is clear is that the probate judge had no jurisdiction to try and adjudicate the cross-claim. The COB was invalid. Attorney Fanger, in effect, stipulated to its invalidity, and appellees cannot meet their burden under MAT, HSBC Bank USA, NA versus MAT, to show that they have a potentially valid claim. They argue 3 procedural defenses. One is waiver. That's nonsense. Subject matter jurisdiction can't be waived, and I argued the issue in front of the probate judge. The next one's estoppel. That's nonsense. There was no estoppel event here, and this court already ruled there's no jurisdiction by estoppel in McCracken versus Sears Roebuck. And the final one was mootness, and I submit that the issue of subject matter jurisdiction cannot be moot when they're continuing to prosecute the cross-claim against Linda, and they're deciding that Linda doesn't have standing based on their adjudication of the cross-claim.
Excuse me, 2 minutes, counsel.
Okay, so that brings me back to the attorney's fees, Your Honor. As far as attorney's fees go, they weren't entitled to attorney's fees, period. Linda paid $22,500 per order of the probate judge on a claim that was valid, never became valid, should have been dismissed on summary judgment. and a claim that they're also guilty of unclean hands and continuing to pursue and filing a cross-claim when they knew that the claim was invalid and their cross-claim was false. This is also as a matter of subject matter jurisdiction. This court held in One Beacon America Insurance Company versus Narragansett Electric that as a matter of subject matter jurisdiction, a court could not condition a dismissal under Rule 12H3 for a lack of subject matter jurisdiction on the other side paying the dismissed party's attorney's fees. This is an even more flagrant case. The judge actually awarded attorney's fees on behalf of a claim that should have been dismissed. And finally, this issue came up in Attorney Fanger's appellee's brief, citing the case of Howe v. Tavarian, and that is that the probate court never had authority to assess fees under 215 Section 45 because this was an equity case. It could have been brought originally in the Superior Court. In fact, it was originally brought in the Superior Court. So we have an invalid claim over which the court had no jurisdiction, awarding fees over which it had no authority to award. Ms. Rory respectfully requests, Your Honors, that you reverse the probate judge and grant her motion for summary judgment, dismiss the appellee's cross-claim, and order appellees and their counsel to repay to her jointly and severally the $22,500 she paid to Attorney Fanger per the probate judge's order. Thank you, Your Honors.
Thank you, counsel.
May it please the court, good afternoon. My name is Alan Fanger. I represent Jean McLean Peterson and Scott McLean, the appellees. Your Honor, the trial court judge faced an interesting situation when she was trying to interpret the provision of this annuity policy. That's really the crux of the issue on appeal. The language of this particular provision suggests it's almost like a joint tenancy with rights of survivorship, because it says unless you direct otherwise, if you have two named person or persons who survive the annuitant, the beneficiary will be the named person or persons who survive the annuitant, and any death benefit will be apportioned equally among them. So when confronted with this difficult issue, the trial court, in trying to give some credence to the intention of Edward McLean Sr., the annuitant, decided that the appropriate way to treat the policy was as if Neil McLean had died. And as a result, decided that because the interpretation would result in Neil McLean's interest essentially being conveyed to my clients, who happen to be his siblings, that led to a finding that Ms. Rory, as personal rep, lacked standing. And this resulted not in summary judgment, it resulted in a dismissal. And with that dismissal, Ms. Rory, as PR, I mean, the ballgame was effectively over, and she had no standing to be able to argue the issue of delivery. Now, I will readily concede, I didn't even take up delivery at the trial court level because the issues between the originally designated beneficiary, who was the annuitant's son, Edward McLean Jr., and my client had been settled.
What was the date of that settlement agreement? I see it in record appendix at page 462. I see a file stamp date of November 30th, 2020, but the document itself is undated. Is there any evidence in the record as to the date of that release and settlement agreement?
Nothing, Your Honor, other than number one, its date, and number two, the docket entry.
Well, when you say its date, the document itself is undated, so what do you mean by its date?
No, the date on the docket that reflects the filing of the settlement agreement.
So we know that it was executed sometime on or before November 30th, 2020, but we don't know if it was the day before, the week before, the year before. Am I right about that?
Well, there's no date on the document itself. In other words, it doesn't contain like a line that says subscribed and sworn this
Right.
date. I can represent that it was signed at probably at the latest 1 or 2 business days before it was actually filed with the court.
But other than your representation, which I have no reason not to take, it's just not part of our record. There's nothing in the record that would allow us to conclude that.
Correct. What the court has is the date stamp and the docket entry, but it doesn't have the date that it was signed. But there was, in any event, a good reason for matters to be settled between the originally designated beneficiary and my clients. After all, this, at the time in 2020, litigation over this was entering its 8th year, had begun in the Superior Court, had been dismissed for failure of Ms. Rory's counsel to comply with the discovery order. There was then a motion to vacate that dismissal, evidentiary hearings, and a denial of that motion, and a footnoted finding by the Superior Court judge that the claims lacked merit. So having gone through the Superior Court and then having Ms. Rory file a new action in the probate court, Mr. McLean Jr. and my clients essentially agreed that we would take the laboring oar going forward, and as a result, matters between the parties were settled. And for that reason, certainly having been essentially exited out of the case via dismissal, Ms. Rory was not in a position to make arguments on summary judgment. And I would note that...
Well, can I just pause you for a minute there?
Right.
My reading of the record is that the order you're talking about, the judge's memorandum and decision, came out in early October of 2020. I'm going to say the 8th, but I'm making that up, so I might be off by a few days. And then the actual docket entry, the judgment, was not entered until November of 2021. Am I correct about that?
I believe that's correct. There were issues concerning attorney's fees that had to be litigated and the like.
And so in that intervening period between the memo and order and the judgment, Ms. Rory was still a party to the case, notwithstanding the judge's legal conclusions. Is that right?
Well, Your Honor, the only reason she was still a party to the case is we were seeking attorney's fees. And we actually moved twice for attorney's fees. And we were awarded fees twice. The first time...
Right, but I don't want to get off track because we only have a limited amount of time, and as you know, this is a voluminous record that goes back many years. So one of the reasons I asked you about the date of that settlement agreement is that, as I'm sure you know, on July 23rd of 2019, in the Neil's bankruptcy case, and I use his first name only because there are a lot of people with the same last name in this case, the judge entered an order after agreement from the parties, finding that the change of beneficiary form transmitted to AXA on November 12, 2013 is null and void. What, if anything, does that have to do with the claims by your McLean clients to the proceeds of that life insurance policy under that form?
I don't think it has anything to do with that, Your Honor.
Why?
For 2 reasons.
Okay.
Number one, it was a stipulated settlement. There were no findings based on presentation of evidence. Number two, my clients were not parties to that particular proceeding. I can tell you that the strategy that led to that ultimate issuance of a judgment by the bankruptcy judge is transparent, which is, I think it was designed to try to give them a lever to use in this case. But my clients can certainly not be bound by some sort of finding in the bankruptcy court where they weren't parties. They had no opportunity to be heard. The cases cited by my brother with respect to the policy language are highly distinguishable. Like the Kruger case, for instance. In Kruger, the policy said that it went to the beneficiaries in equal shares if living. And the court, looking at the plain meaning of the beneficiary designation, concluded quite properly that what that meant was if a beneficiary was no longer living, that deceased beneficiary's interest would pass to the estate. In Tyler, contrary to my brother's contention, Tyler stands for the proposition that a beneficiary can actually elect to bring an action in his own name or in the name of the estate. It did not state that the estate itself or the personal representative could do so. And in Betancourt had nothing to do with an insurance policy. It had to do with a contract to make reciprocal wills where the wife's will provided that the surviving spouse had to sell jointly owned property. The husband died and the wife refused to sell the property pursuant to this agreement, and the court held that the husband's estate had standing to enforce the contract. Highly sensible conclusion, but not the facts not anywhere near this or analogous
In
to
1903, Massachusetts being one of our older states, the Supreme Judicial Court was asked to decide in a case where the plaintiff was the widow of a man who she contended had been unduly influenced by his son to change the terms of a life insurance policy of a will before he died. And the Supreme Judicial Court said, if the property was wrongfully conveyed, as the plaintiff alleges, the executors or administrator, who are the personal representatives of the deceased, are the proper parties to recover it for the benefit of those who are entitled to it. The title to all personal property of a deceased person vests in his executor or administrator by relation from the time of his death, and no one else can maintain an action for it. That's Flynn versus Flynn, 183 Mass. 365 from 1903. Why doesn't that case mean that Ms. Rory, as personal representative, had the right to pursue this claim?
I believe, Your Honor, you were discussing a case that involved probate assets, if I'm not mistaken.
Yes.
All right. This is a non-probate asset, and the case or the cases treat it differently. And I did cite a series of cases, admittedly not in this jurisdiction, that stand for the proposition that only the earlier designated beneficiary has standing to challenge a change of beneficiary form where the estate is, mention of the estate or the decedent is not contained anywhere in the policy. So I do think there is an interest, unquestionably, if somebody, a third party takes action to divert probate assets, the personal representative would be the logical individual to have standing, but not in a situation such as this where there are specifically designated initial and subsequent beneficiaries. If I can just address the attorney's fees issue in the limited time that I have left. The court, as I mentioned, awarded attorney's fees twice. First following what I believe was the motion to dismiss, and then later when the court denied summary judgment. The court was positively authorized under Chapter 215, Section 45, to levy that fee award. The statute says that fees may be awarded where justice and equity so require. The trial court judge did not abuse her discretion when she looked at the considerable litigation involving this policy, first in the Superior Court, then in the probate court, and how it was unnecessarily perpetuated. The issue in the probate court judge's mind was clear, and so this court should affirm that award on the basis that the trial court judge had sufficient discretion, which she did not abuse in taking this fee application. And by no means were all the fees that were sought awarded here. So the decision does reflect a studied examination of the record by the trial court that justified the award.
Counsel, before we run out of time, can I ask one question? And again, assume for the moment the person takes out $1 million life policy, names their sole child as the beneficiary, and then somewhere along the way there's a partner or a friend involved that then falsifies some documents or unduly influences the person to change the life insurance policy, person dies. What recourse does the child have, who is the original intended beneficiary?
Well, it depends. If the child was a minor.
Let's say it's an adult child.
They're an adult child?
Yeah.
Well, they would have standing. It would be they and they alone who would have standing to challenge that transaction.
Right. And you're saying the difference here is that the plaintiff was never named as a beneficiary. Is that the distinction here?
Correct. The personal representative acting on behalf of the decedent had no standing because the estate had no interest in a policy that the original beneficiary, if invalidated, or to my clients as Neil McLean's siblings, the quote, surviving beneficiaries under the policy, the later designated beneficiaries.
Well, I mean, I'm not 100% following you on that because you've left a sentence out from this policy, which is, we have one legal fiction here. We have one alive but legally dead person, according to the judge, right, which is Neil. And then we have one actually dead person, which is Edward Sr. But the policy says any part of a death benefit payable for which there is no named beneficiary living at the annuitant's death will be payable in a single sum to the surviving owner. Now, Mr. McLean Sr. was the owner, and then of the policy under its terms, right? And Neil was not dead. So it seems to me, inarticulately though I'm expressing it, that there was actually a legal interest in the owner, which I guess I don't know why that wouldn't pass. I don't know why the legal standing to enforce that interest would not pass to his personal representative. I understand what you're saying about the money passing outside of probate, but this is a different question, which is the legal ability to enforce a right.
If you could just repeat that provision to me, because I...
Sure. You mean the part I read?
Yeah.
It's Record Appendix page 316, and it's the one page we have from the policy. Any part of a death benefit payable for which there is no named beneficiary living at the annuitant's death will be payable in a single sum to the surviving owner. Now, maybe the problem is he can't both be dead and be surviving, and so that covers a situation in which, for example, he and his wife had together been the owners, which I understand is not the situation here.
Right. I think as I understand it, there were other beneficiaries living as of the annuitant's death.
Right. No, I understand. I mean, if you assume that the COB form was proper, which is, an assumption.
Well, but I don't even think, and I don't mean to sound like a broken record here, but I don't even think with respect to the standing issue that we even get to that part because the issue of delivery would have been decided on summary judgment, and because they were dismissed out of the case, they had no right to step in and be heard with respect to summary judgment.
But if you're going to be dismissed out of the case, a motion to dismiss takes all of the allegations in the complaint as true. Have I got that part right?
Under 12b-6, correct.
And the complaint alleged that the COB had been fraudulently executed and never properly delivered, correct?
Correct. That's correct.
So I don't know how you can get dismissed on that assumption and then not get a chance to prove that it's true later because you're already out of the case.
Well, if the policy doesn't give you standing, then you can certainly allege it, but if the construction, the sensible construction of the language that I had read earlier is that that my clients, that either my clients are the true beneficiaries or Mr. McLean Jr. is the true beneficiary, then they don't have standing. That's the gist of what I've been arguing. If there's nothing further, thank you very much.
Thank you both for your helpful arguments. The case is submitted. Our next case is Department of Children and Families and Others versus Father and Another, 23P0224. And my understanding is that counsel for the department and the children will be splitting time. Attorney Kernan, 7 minutes, Attorney Bagnall, 4 minutes, Attorney Rosenthal, 4 minutes, in that order, is that correct? Okay. 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 So it'll go still 7-4-4. Is that correct? Okay, thank you. And counsel, I just remind all parties that this matter is impounded, and please do not mention any names or use pseudonyms if you do. Of course, certainly. And I'm sure if you just give Officer Alpert a minute, he'll help you with that. Okay. Attorney Medeiros, thank you for your patience. Whenever you're ready.
Good afternoon, Your Honors. I'm Linda Medeiros. I represent the appellant father in this proceeding, who is requesting today that the judgments of the trial court be reversed and the case be remanded for a new trial. This is based on the termination of father's parental rights, based on several erroneous findings by the trial court that formed the core basic foundation of the conclusion that the father was unfit. And I will discuss in more detail the erroneous findings and the concerns. But essentially, the finding that he had sexual relations in the presence of the children, that he abused alcohol and failed to document and verify his sobriety, that he had not addressed domestic violence, and that he had physically abused the oldest child. The SJC, in adoption of a minor number 2, in 1975, held that a trial judge's conclusion of parental unfitness by clear and convincing evidence is only entitled to deference when the troublesome facts are addressed by the court in the findings. And the very mandate of a trial judge in a termination of parental rights proceeding is that they must find clear and convincing evidence by paying attention carefully and closely to the evidence before them. And that is where the due process comes from in a termination of a parental rights proceedings, is in that very task of the trial judge. And that is what failed here. The task of the trial judge, that step 1, is what failed in this case. And I would point the court to the way that the trial began. The judge signaled at the start of the trial that she was not going to be paying close, careful attention to the evidence when she refused to hear the motions in limine that the father's counsel had filed. And he requested that they be heard, and she indicated that if father appealed, she would, of course, issue official rulings on the motions in limine, which, of course, is not how trials work. So we had, from the start, a record of approximately 1,000 pages of exhibits and motions in limine that father's counsel had filed to strike portions of the exhibits that just simply weren't heard. And so when appellees file briefs that say we're only citing to facts that are found by the judge or uncontested in the record, it's impossible to know because we had motions in limine that were never addressed.
And father didn't appear for trial, is that correct?
He absolutely was not present for trial. He had counsel representing him, and those motions were filed and properly noticed and there to be heard, and the judge declined to hear them. So addressing the particular erroneous findings, I would like to highlight, I think, more, I'm sure you've read my brief, so highlight more the responses that I would make to some of the arguments raised by the appellees. So with regard to the allegations that my client engaged in sexual acts in the presence of the children, DCF and counsel for the youngest child argue that father intended to do that even if it didn't actually happen, and that is sufficient for a judge to terminate parental rights or to certainly find as a factor of unfitness. However, the judge actually found that it did happen, not that it was intended or planned. So the finding is inconsistent with that argument. I would also point out that the youngest child's counsel argues that this was a single-room hotel, and so clearly the whole thing was what he had planned to do, was to have sexual relations in the presence of the children. But we do know there were two rooms. There was a bathroom and the main room. So even that is a presumption that is not supported by the record. So the judge found that it happened. The record does not actually support that it happened. Father's counsel objected to the characterization when the testimony was elicited by the DCF counsel that the social worker testified that this was what the record would show. And there was an objection made at that time as well. So on cross-examination, the social worker did acknowledge that in the original affidavit, when DCF filed the CMP, DCF itself never made that allegation against the father. And so somehow, an incident that happened that he was not accused of doing at the time the children were removed just sort of morphed into something that became part of what the whole story of the case was, even though it had not actually happened that way. And that is just patently unfair to any parent seeking justice in the courts. I mean, they are entitled to not have that kind of distortion be carried through a case and have a judge who is supposed to be paying close and careful attention to the evidence not recognize the troublesome history of how that finding or how that testimony came to be so distorted from where it began.
Understanding your point about the specific finding, and I'm not taking issue with your argument there, would you agree that there was evidence from the father's report that he had invited two women over for what was reported to be a booty call into the single room with a bathroom, and that the judge was aware, had heard that much evidence anyway?
Certainly, yes. The concern is that the judge actually found that it happened, and that is where I believe we have gone too far in terms of that particular finding. And in conjunction with that particular finding, there was also a finding by the judge that the woman in the bathroom had overdosed, which in fact was also not supported by the evidence.
Would there have been an inference based on the based on the evidence that the father had believed that the woman was unrousable because she was taking methadone? Was there an inference that could be drawn from that in fact there was an overdose?
With regard to the incident that happened in the hotel prior to the children's removal, I would argue no. So the reporter who called the police reported that the woman was in the bathroom and lying on the floor, and she asked her to leave. So somebody who is passed out or overdosing is not going to get up and leave.
Was there evidence that she actually did leave?
When the police arrived 10 minutes later, there was nobody in the hotel room with father and the children. So there was a 10 minutes lapse of time between the call to the police department and them being there. The woman actually reported the children were alone as well, which also was not the case. The father was with the children as well. So the reliability of the reporter is questionable to begin with, but then you have a 10 minutes lapse of time where she told a person to get up and leave, and the person got up and left. So this is not somebody who has overdosed in the presence of the children. So I would argue that finding as well is just simply not supported by the evidence.
If the finding stopped at passed out, would that be supported by the evidence?
I'm sorry.
If the finding simply stopped at passed out without the reason being necessarily a narcotics overdose, would that be supported by the evidence in the 51B or the reasonable inferences that could be drawn from it?
There was an allegation that she was passed out simultaneously with an allegation that she told the woman to leave.
Right.
So again.
So that, it seems to me at least, that's more of a weight or in a credibility assessment, right?
To the weight of that.
Okay.
Yes, on that particular point. But again, what the judge found was that the woman had overdosed in the presence of the children. And when the police arrived, the children were fine. Father was not observed to be intoxicated. There were no concerns. They actually searched the room, and they found no paraphernalia for drugs. They found no drugs. So moving on to the evidence of father's alcohol abuse and failure to verify his sobriety. And to Judge Brennan's point, I would argue that the department certainly correctly points out that the judge does have discretion to weigh credibility. And so I certainly would agree that that is an accurate statement. With regard to the evidence of fathers drinking heavily during the incident that happened approximately 2 weeks before the children were removed involving the oldest daughter, who required hospitalization during a psychotic episode. So the evidence that father was drinking heavily was reported by the daughter, who was 13, in a psychotic episode. And there is ample evidence during that investigation for the trial judge to see that the child was psychotic. She was believing she was a demon, she was believing father was a demon, and she required hospitalization. She needed restraints. She actually, at one point, assaulted the father. This was a child who was in a very troubled state.
May I ask, excuse me for
Yes.
interrupting, but may I ask, that was a different incident from the broken nose incident, right?
Absolutely, the broken nose was
What about the
many
broken
years
nose
before.
incident? Because it seems you take issue with that, but then as I read through the 51B, there were neighbors, witnesses who seemed to give statements that would be consistent with the finding that the father was punching his daughter or hitting his daughter as she sat in the back seat, threw her back there, and saw his arms flailing toward her, and then she ended up with a broken nose. And while it may have been disputed later, it seems to me, again, the judge could certainly read between the lines there and draw her own conclusions, no?
So I will shift gears and answer that question. That particular 51A and 51B investigation is lengthy. As you've read, there were numerous people that the DCF investigator interviewed. DCF did not support those allegations.
Right, but you're not suggesting that judges, bound by DCF's conclusions. No offense.
Well, I am, to some extent. I did cite two cases in my brief, adoption of Nancy, where the SJC found that unsupported allegations cannot support a finding by a fair preponderance of the evidence that an act occurred. So I would point the court to that. And also in adoption of Eden, which is also in my brief, where it is a bedrock principle of due process that parental rights cannot be terminated based on unproven allegations, even serious ones. And so there certainly would be an argument that I would make that this is not the same. DCF, that particular incident happened years before the children were removed. And DCF did an extensive investigation and made whatever findings and determinations they made based on the totality of information reported by a lot of different people. So if they have not supported it, I would argue that the case law suggests that these unsupported allegations are not sufficient for supporting a finding by a fair preponderance of the evidence. So I think I will stick with this argument just because we're here with the physical abuse.
It looks like about a minute and a half left, just briefly addressing the adoption plan.
Okay.
Please.
Thank you. With regard to the youngest child's adoption plan, in particular, counsel for DCF and the child actually do not address the argument that I made in their briefs. So under ERISA, the recruitment for a child in a residential home is not disputed as an appropriate plan. But ERISA was clear that they upheld the recruitment plan for that child because because the court had adopted some extra steps that the court would be doing to monitor to make sure that permanency was achieved, which did not occur in this case. And with regard to this child, not only did those steps not occur, we had a situation where the department agreed with the mother at the start of the trial to not terminate her parental rights because she objected to adoption as a plan for that child. So we ended up with a child who father's parental rights are terminated, but mother's are not. And yet there's an adoption plan, except there's no legal mechanism to actually achieve adoption for him because the mother's parental rights have not been terminated. And I would point out that there has been no case cited that would support the legitimacy of that. And in fact, the mother is not only unfit presently, but not able to become fit in the future due to her disabilities. So this is not a situation that could change and he could go back to his mother. Thank you. Unless anybody has any questions.
Thank you very much.
Thank you.
Attorney Kernan.
May it please the court. Jennifer Kernan for the Department of Children and Families.
Could you do me a favor and just pull your mic a little closer?
Yes.
Thank you.
Okay. I just want to start with 2 points. One that Justice Hand brought up. You mentioned methadone. I believe Your Honor was thinking of an earlier incident where there was indeed a woman passed out. This was at the time when father was living in an apartment with all 3 children. So that did occur, but it was just earlier and separate from the incident where
Thank you.
The woman, I think I referred to her as BC in my brief, had called the police to report that there was an older woman lying on the floor in the bathroom with a bag that BC knew to be used as, or holding drug paraphernalia. The second point is with regard to motions in limine. Father indicated that the judge had declined to address motions in limine and had mentioned that father brought that up at the beginning of the trial, the transcript. In the transcript, pages 16 to 17 is the discussion at the beginning of the trial where one of the attorneys does mention their motions in limine, and I believe that was actually child's attorney, Attorney Sniffen, who did bring up motions in limine. Father did not mention any of his motions in limine at that point. And the judge did say that if Father does appeal, they would have to make official rulings on the motions in limine. But the judge did state that preliminarily the exhibits will be admitted via Luke, and that's on page 17 of the transcript. And I would direct Your Honor's attention to footnote 1, I believe it was, on the judge's relevant procedural history section that indicates that, and I'm sorry, I don't have the record page for that, but it indicates that 51 A's and B's were admitted to set the stage, and then also, I think the last line in that talks about Luke and says that any out-of-court statements that are not admissible under their own separate exception would come in DCF official reports pursuant to Luke as long as they were identified and available for cross-examination. And that sort of ties into Father's arguments about the statements made by the oldest child when she was hospitalized. This was just prior to the removal. I believe it was late September 2017 when child did make the statements that Father had hit her. At the same time, she thought that she and Father were both demons. With regards to that, there's enough corroborating evidence to indicate that she was actually accurate in that. There was a guest at the motel, one guest, and also a front desk worker. They are named and identified in the reports, so Father could have had them come testify to address any concerns about that. And generally, I think that Father narrows the issues here, pinpointing specific issues such as intoxication and whether or not Father actually engaged in sexual acts in the presence of the children. Those incidents are examples of a bigger picture where it's Father's judgment that the court is really questioning here. He consistently demonstrated an inability to cope with the children's needs and behaviors, failed to provide a stable home free from verbal and emotional abuse, failed to engage in services designed to promote reunification, and failed to cooperate with the department. And the specific examples that Father's counsel has raised are bigger than the small identified part. They are, that was oddly phrased.
I think we followed.
They're representative of the bigger picture, and that bigger picture is that Father consistently makes poor judgments with regard to the safety and care of his children.
Is it your view that if we were to disregard the particular handful of facts that Father points to as clearly erroneous, that point would still be supported by the record?
I'm sorry, that the point?
Is it your view that if we were to disregard the allegations or the findings rather, that Father identifies as clearly erroneous, that the point that you just made about Father's judgment and the significance of that would still be supported by the record?
Yes, and I think I still maintain that the individual findings that Father challenges as clearly erroneous are not actually clearly erroneous, with the exception of the sexual acts actually happening. I do recognize that the record indicates more that Father was trying very hard to make sure that did happen, but was unsuccessful due to the woman, BC, calling the police. But the fact remains that it was indeed Father's intention, even if there was a bathroom with a door, it was Father's intention to get what he was seeking at that point with the children in the room with him. And there is indication based on BC's conversation with the police as well as the investigator later that the children were awake at that time. She indicated that they had been talking to her and engaged in conversation with regards to who the woman lying on the floor was. Overall, the record supports father's significant history of an inability to address the children's behavior, meet their needs. The record is replete with information regarding father's inability to get the children to school, their attendance issues, hygiene issues, and even if this court were to disregard the challenged findings, there's still ultimate support for the judge's termination of parental rights decree. And if there are no further questions.
Thank you very much.
Thank you.
Attorney Rosenthal.
May I proceed, Your Honor?
Yes, please.
Members of the panel, may it please the court, Steve Rosenthal, counsel for the youngest boy in this case. My client asks this court to affirm the lower court judgment. My client is 11 and a half years old now, but he performs academically at a 6 or 7 year old level. He's diagnosed with a moderate intellectual disability, severe PTSD, and ADHD. He also has serious behavioral issues.
Could I interrupt you and ask you do you have a perspective on the father's argument about the impropriety of establishing an adoption plan for a child with one parent who maintains parental rights?
Mother is in no position to parent this child, and mother's arrangement is in the nature of an open adoption agreement. May not specifically be named that, but that's the effect. As a practical matter, it's unclear whether this child will ever be adopted. As I said, he's 11 and a half now, has very serious problems, requires a safe and structured setting, and it's unclear whether, certainly not to go outside the record, but it's obvious that there is no adoptive or pre-adoptive source available at this time, and perhaps not for the foreseeable future.
But is there case law you're aware of that speaks to the ability of the judge to approve an adoption plan where one parent still maintains parental rights?
I haven't identified any case of that nature, Your Honor. Regarding my client, it's my client's position that further contact with father is not in child's best interests. He has extensive needs that father has never shown the capacity or the desire to provide. Child takes 10X for ADHD, Topamax, an anticonvulsant, and melatonin for sleep. Father, on the other hand, has stated, and this is at finding 81, conclusion of law 10, that he doesn't believe in medication. He's minimized the severity of child's behaviors, as the judge found at finding 76. In finding 79, in November 2016, father couldn't be reached for more than 4 hours when this child was in crisis at his daycare center. All of this is consistent with father's history of rejecting treatment for his family members. The trial judge found at finding 16 that father demanded that mother end her mental health treatment. And when a structured school setting was recommended for child's older sister, father said he wasn't interested and that he didn't think it was necessary. Child needs a safe and structured environment. On the other hand, father's visits and contacts with child were inconsistent at best, causing child terrible anxiety.
I don't mean to interrupt you, but here I go.
Yes.
Just to circle back one question, and again, maybe obvious. Assume that we were to remand this on the adoption plan issue, if there's no case law to support what the judge did. Do you have a sense as to whether the father would have standing if we find that his parental rights were terminated to have any role in that at all?
If his parental rights have been terminated, then he has lost the ability to assent or dissent to any adoption plan. So it might be...
The practical effect of our doing that would be what? If we send it back to the judge? And the mother's not really...
Not being a judge, Your Honor, I don't think I am equipped to answer that question.
Yep.
You know we were all just lawyers before we got up here.
That's true. That's certainly true. I just want to point out...
I'm going to have to ask you to leave it there, I think.
I'm sorry. All right.
Thank you.
In that case, I'll rest on my brief.
Thanks very much. Attorney Bagnall.
Good afternoon. May it please the court, my name is Attorney Bagnall, and I represent Child 2 or Child C in this matter. And on behalf of Child C, I'm asking this court to affirm the lower court's decision terminating father's parental rights to him. You may recall that at the beginning of this case, my client was 8 years of age. He is now 14. He was in 2nd grade, and he is now attending 9th grade. This case has proceeded for some time. And on behalf of him, at his request, he'd like the case to end. Clear and convincing evidence supports the trial court's decision here that it is in my client's best interest to terminate father's parental rights, where father repeatedly failed to provide minimal care to my client. More importantly, he refused to engage in services that would have addressed his shortcomings, just refused to participate in those services. Therefore, in the 5 years from the time that the children were removed to the termination trial, 5 years, he failed in any way to acquire any of the parenting skills that would have been necessary for him to get one or all 3 of his children back in his custody. I'd also like to remind the court that mother's rights to my client are terminated. So to address the panel's question, I'd ask the panel to be clear if they were inclined to remand a portion of this case to rectify the questions regarding mother and youngest child's position. It's a legitimate issue. My answer to you is that if there is one parent whose rights are not terminated, the child is not adoptable. And my understanding of the case law and procedure, that does not apply to my client. And I'd ask the court to be clear in that remand and clear in the fact that hopefully this court is going to affirm the termination of father's parental rights, at least to my client. As I indicated, my client was 8 years of age in 2nd grade. 2017, when he was removed from his father's care, he is now 14 years of age and halfway through his 1st year of high school. He continues to live with a maternal cousin and family, the adoption plan for him. And initially he was negatively impacted by the chaotic, nomadic lifestyle that father provided for him, 1 through 7 years of age, resulting in him displaying symptoms consistent with reactive attachment disorder, anxiety disorder, and oppositional defiance disorder. He is doing very well today, and on behalf of him, I would respectfully request that this court affirm the lower court's decision terminating father's parental rights to him and free him up for adoption. Thank you.
Thank you very much. Thank you all very much for the thoughtful briefing and argument. We will take the matter under advisement, and it's submitted. And our next case today, CASEY Fleming and others versus Town of Oxford Zoning Board of Appeals and another, 2023 P0332. Good afternoon.
Good afternoon, Your Honors. May it please the Court, my name is CASEY Fleming, and I'll be presenting during the appellant's time. This is a case that's very simple, but has been bogged down with a great deal of extraneous arguments and misrepresentation. The only underlying question the Court needed to rule on was the question of statutory construction defining agriculture and livestock, which are both well established in law since the Curvin case and the Stieg case that I cite to in my brief. It's been well established since the SCIT v. Planning Board of Braintree case that a use that is as of right cannot be made subject to a special permit and it cannot be prevented. And because of that, if the court had ruled that this is an agricultural use, that's dispositive of the entire zoning order. She didn't need to reach any of the other questions.
But the court ruled the opposite.
She did, yes, but so I'm arguing that, well, I'm arguing that all of her rulings were error, but so if you agree with me that the use is agricultural, you don't need to reach anything else.
Understood.
So I've arranged my brief, the arguments in my brief, as sort of like dominoes. If you agree with me on one of the earlier questions, it knocks down all of the subsequent questions.
Can I ask you a question about the record? I did not see in the record that we have before us any, well, I saw a little, I guess. I did not see most of the factual material that underlay the undisputed facts that had been submitted to the land court judge. Did I just miss that, or do we not have it?
The factual material that was provided with the summary judgment motion was, I provide them in the list of exhibits I cite to them in Record Appendix Volume 2. Sorry.
No, I think I see what you're talking about. So looking at the, on volume 2 of the record appendix, looking at page 2, it says exhibits, and then there are a number of things listed.
Yes, so there's the Oxford zoning bylaws. And I'm sorry if I put this in a confusing manner. My interpretation of the rules, perhaps wrongly, was it said include citations to the exhibits provided. And the rules said some of these things were supposed to be in the addendum, so I didn't put them in both places.
Okay, but I can look in the addendum maybe and find some more of these factual.
Yes, so the Oxford zoning bylaws and the Fink case are both in the addendum to my brief. And then also was submitted was my deposition and Exhibit 1 to my deposition, which was my answers to interrogatory requests.
But we don't have, for example, any photographs that were taken when the building inspector came to the property.
There were none entered into the record.
Okay.
And so the judge discusses that in the summary judgment transcript, where she states that there were photos raised during the ZBA decision, but they were not submitted to the land court in an admissible form. So she could not give any consideration to that.
Mr. Fleming, on the construction or the definition of agriculture, it seems to me, and again, but correct me if I'm wrong, that the cases that you cite on that precede the statutory amendment in 2007 that defines agriculture. Does that have any impact at all on your argument?
My argument is that it does not. The town argues that it does.
Right. So tell me why it doesn't.
Well, so the definition has many clauses, and I realize this is not controlling, but I think that it was discussed very well in the Clinton case that I provided in the addendum to my brief, where the judge states the definition of livestock was not changed. There's many clauses in the definition. One of them is livestock, including horses, and it leaves livestock undefined. So livestock is still only defined judicially.
Okay. It just seems that the essence of it is that it's more for sort of like what we normally understand to be farming or agriculture, as opposed to selling dragons. No?
Well, I mean,
Where do I find, where could you point me to that would support the interpretation of the statute that might cover someone who wants to sell dragons and turtles?
well, so that would come from the judicial definition of what livestock means.
Okay.
So mink
that's the
mink are not livestock, we know, right? There's a case,
But they are agricultural now because they built into the definition fur-bearing animals. So
right, and so that's a change that we might suspect, but who knows, was deliberate on the part of the legislature to bring in that kind of animal cultivation, for lack of a better word, under the definition of agriculture. But I'm not sure that that helps you in the sense that if there needed to be a change to accommodate mink because they weren't what Judge Brennan refers to as sort of normal farm animals, why wouldn't there also need to be a change to accommodate pets?
because there was never a case that needed to be overturned. So prior to the Dover Amendment, you have rulings that say dogs are not agricultural. Those cases are cited too in the McDowell case. Same with horses, same with pigs, which seems kind of surprising, but that's what they ruled, and mink. Those are the four animals. Then the Dover Amendment gets passed, and you have Kirven, Steig, and McDowell all saying dogs, horses, and pigs are agricultural. The only one they never revisited was the mink. A case just never came up about mink. And when they incorporated the definition of livestock, they specifically included pigs, horses, and fur-bearing animals. The only animal they don't mention is dogs. But they also knew at the time that they wrote the definition that in the McDowell case it had already been determined that dogs were agriculture, or that were livestock, and that was an agricultural pursuit, and they did nothing to limit that definition. And they knew from Steig and Kirven that the appeals court had determined that the definition animals of any kind kept or raised for use or pleasure is a valid definition of livestock. They didn't do anything to overturn that. And I would argue they included livestock, including horses, and then they also included separately domesticated animals such as, and then they list a few types of domesticated animals. Those are two different clauses. They need to be interpreted so that they aren't the same. Otherwise...
Excuse me, sir. There's some finding, right, by the animal, or some statement by the animal control officer that bearded dragons are not, what's the word you just used, not pets or domesticated household pets. Is that right?
It's the building commissioner, just to be more precise.
Right. I
Record
thought it was
appendix
based on
volume
that.
2, page 19.
Okay.
Well, so there are statements to that effect in the ZBA decision. None of that was entered into the record of the land court case, though. There was no affidavit given. There was no testimony given. The only affidavit that was submitted was the affidavit of the new building commissioner, which I argued in my brief does nothing for the town's case. It just repeats conclusory statements that are not within his knowledge, and that it's an attempt to try to rewrite the decision, because I don't see the decision as providing actual reasons for its decision. And I discussed that in my reply brief. It's what the court has referred to as just empty mouthings of the bylaw criteria. So what the land court did is, to me, the controlling case law is Steig and Kirven. The appeals court was aware of the Proctor case, which was prior to the Dover Amendment when it made those rulings, and it was a conscious decision to include the definition animals of any kind kept or raised for use or pleasure. So the land court is a lower court. I think she's bound by that decision. And in the McDowell case, the court states that cases prior to the Dover Amendment that turn on the local zoning bylaws definition of the word farm or farming are not controlling post-Dover Amendment, and where you don't have a zoning bylaw that is constructed in that way. And that's the case that you have in Oxford. I don't need to show the use is a farm or the property is a farm. I only need to show the use is an agricultural use.
So McDowell, in the court in McDowell also says, livestock in turn is defined as, quote, domestic animals such as cattle or horses raised for home use or for profit, especially on a farm. And that's citing a different dictionary definition from the one that the court uses in Stieg, which was 5 years earlier.
Well, so Stieg uses both. So in the Curvin and the Stieg case, they both provide both definitions. And there's no analysis. They don't draw a distinction between them. The argument that I make in my brief is, so to use the Stieg case, for example, they were horses. There was no question they were domesticated, which is a little interesting because horses aren't always domesticated. They were introduced to North America. There's now wild horses pretty abundantly in more southern and western states. And when
They're feral horses, in other words.
Exactly, and when they get too populous, people have to capture some of them, and then they are brought into a domesticated setting. But under the definition of domestic, from day one, they're not tame, they're not accustomed to living in human habitations. So in theory, you could have two different horse farms right next to each other, exact same conditions, but different populations of horses, one captured from the wild. We're trying to make them domesticated, and the other born in captivity. Is one an agricultural pursuit and the other's not? But in this case, the judge states that the animals are not domesticated animals. There's no evidence to support that. All the evidence in the record shows they are domesticated animals. They're sold as family pets. They're one of the most popular pets in the country. They're sold, if you walk into a Pet Supplies Plus, a Petco, a PetSmart, they sell reptiles. It includes turtles and bearded dragons. And
Is there any evidence in the record about the names of the turtles?
No, there's no evidence about it, but the town claimed that we did not testify during the ZBA hearing that the animals have names. That's accurate only in the sense that there was no questions or discussion as to the animals' names. There's lots of things I didn't testify to during the ZBA
I ask
hearing.
on that point, I presume if your business is to sell animals, you don't name 400 dragons before you send them off to other people, right? I mean,
No, I don't
as a
name them
practical.
all.
Turtles.
But sorry, but I don't mean to make light. But the turtles you did name or you didn't name?
I do name any
all
of
of them.
Well, so most of them, because we breed them, they're babies. Most of them are like golf ball sized. They don't all have names, but I do name them.
Okay. I don't think that's necessarily dispositive whether you name them or not. Is I guess my point. If you, right, whether they have names or not, they are what they are.
Right. Yeah. To be honest, some of my animals that I keep as my pets, I don't name. I know them. They're my pets. They're familiar to me, and they're my escape from world of rules and people. And I go and I have them, and they're just mine. They're not something I need to justify to other people, except for now, but under normal circumstances.
Before you run out of time, I wanted to give you a chance to address the issue about whether or not the nuisance claim was properly before the land court.
Okay. So my argument is that what the town claims is the basis for finding the nuisance that they don't describe is not within the subject matter jurisdiction of the ZBA. What they've done is they have this collection of orders, and they just say, well, all of that is in this case as a zoning order. But I cite to in my reply brief, you can't do that. A health order is not appealable to a zoning board of appeals. Neither is an electrical order or a fire order. And what the land court judge did is she upheld the zoning order on the basis of other orders that have been overturned. The orders, they're not nesting dolls. You can't open the zoning order and then there's a health order inside, and then you open that and there's an electrical order inside. that's subject matter jurisdiction. And it becomes really problematic when you open it and there's an electrical order inside. That's not an electrical order because it was overturned. So what's the nuisance if all the orders were overturned?
And where do we have evidence in the record before us that those orders were overturned?
I cite to the cases themselves in my initial brief. I think it's in my section where I talk about the nuisance. I talk in the request for costs and fees is where I talk about the fact that they were overturned and what the current status at that time of them was. But if I could just address the transcript to answer your question. So if you look at, everyone agreed there was no evidence of a nuisance in the record and that the entire matter turned on what was stated during the January 28th, 2022 hearing. It begins with Attorney Costanzo asks if we have stipulated to a nuisance, because the court has said she wants to create a list of what are the issues before her. And the end result was there were 3 issues. So Attorney Costanzo asked, this is Record Appendix Volume 3, page 39, lines 11 through 16. I'm sorry, not that one. Page 43, lines 6 through 13. She asks if we stipulate to maintaining a nuisance. The answer is, I'm not going to stipulate that it was a nuisance.
Right. I think we are familiar with that part of the transcript.
Okay.
So.
And I provided in my reply brief the standard of law for a binding admission. And I just
let me stop you here. Are there other questions from the panel? I think we're going to have to leave it where it is.
Okay.
All right. Thank you very much. Attorney Costanzo.
Good afternoon, Your Honors. May it please the Court, Nicole Costanzo from KP Law on behalf of the Town of Oxford Zoning Board of Appeals. My argument today will focus on 4 principal rulings why this Court should affirm the Land Court's decision which upheld the Zoning Board of Appeals July 13th, 2021 decision affirming the cease and desist order which required the appellants to cease use of their property for the commercial breeding and sale of bearded dragons and turtles in violation of the zoning bylaw.
You say and turtles, but I didn't see any record evidence that the turtles were currently being sold. I believe Mr. Fleming testified that he had no present plans to sell them. So on what basis is there a cease and desist order regarding the turtles?
Your Honor, the bylaw provides that if you're keeping more than 7 animals other than customary household pets, you need a special permit from the Board of Selectmen. In the record, there is deposition transcripts wherein the appellant testifies that there are approximately 40 turtles being kept at the property. The court found that keeping the sheer volume of 40 turtles in no means is that customary, as that term is understood under just general principles of defining.
Excuse me, that's strictly numerical, right? Doesn't mean, I mean, if you had 3 giant turtles or
8
or 40 teeny tiny turtles, does it make a difference?
Your Honor, I would say that here it does. The zoning enforcement officer did submit an affidavit that bearded dragons and turtles are not customary pets in the town of Oxford. However, I don't even believe you need to go there because, as Judge Roberts had correctly pointed out, the bylaw allows an exception for customary household pets. These are not customary household pets. It's not customary to keep 40 turtles in a household.
Do we think that one bearded dragon is a customary household pet, or do we have anything to say that it's not, or one turtle? In other words, I get that, I mean, if I had, a dog, if I had 40, right, if I had 40 dogs or 400 cats, I think 1 or 2 or 3, or I've had up to maybe 4 at a time.
Your Honor, again, we're not talking about one here. The zoning bylaw is for if you're keeping more than 7.
Right, but in the definition of what is a pet, it just seems to me it's not dependent on the quantity, but the characteristic of the animal in question. No?
I think you have to look at the language of the bylaw as a whole. It's the term pet is quantified by customary. And again, it's not customary in town to keep a sheer volume, to keep 40 pets of any size within the community.
But if there were 40 dogs, so you say if there's 40 dogs, the bylaw would apply?
I believe it would, Your Honor.
Just
and
follow
I
that
think,
out.
again, it has to be read in totality. And if you are keeping that many dogs, then I would refer to the definition of kennel, which those are prohibited in town. So again, I think you have to look at the bylaw in totality.
We'll look to Justice Hershfang's point. What if it was 8 dogs? So that's more than 7. Would you have to get a special permit?
I would say yes, Your Honor.
Okay.
So to begin with, the record
What if you had a
is-
litter of kittens? What if your cat had a litter of kittens and or a litter of dogs, and you have...
If your cat has a litter of dogs, there is a problem.
Fair enough, if your dog has a litter of dogs. But if you had a litter, you had one pet, it just seems to me that if you're defining what is a customary pet, it's either something is or it isn't, it doesn't depend on the number, but again, I'm maybe missing something.
Well, I do, if you refer to the again, I'd say that you have to look at everything in totality. The definition of kennel talks about dogs and other animals being above a certain age. So I think if you have a litter, then that would fall within an exception there. But again, we're talking about approximately 40 turtles and anywhere from 200 to 500 bearded dragons. I think the scope here is very different, and deference does have to be given to the Zoning Board of Appeals, who does have special knowledge of the conditions within the town. And again, so I would say that having that number, the sheer number of animals, is not customary within the town of Oxford, let alone anywhere. And I think as well, Your Honors, that these animals are being kept for sale. You don't keep pets for sale. And so again, I think here that the record is clear that the appellants do have a business selling these reptiles, here be dragons. They've testified in their deposition as to that. And so to say that, and what they say in their deposition is that they're all pets until they're sold, I mean, that I don't think is sufficient under the bylaw. It's not a way of sort of escaping the special permit requirement.
Can I ask this? When you're defining, and then I'll leave the topic alone, although I can't promise it will stay that way, but if the bylaw prohibits a certain number, or requires particular permitting for a certain number of customary household pets, isn't the question whether the pet is customary, not whether the number is customary? And if that's the case, how do we define a customary household pet? Does it depend upon whether those pets are sold commonly, those animals are sold commonly as pets? What's the definition?
Again, I would say that customary is customary within the town of Oxford.
And if the town of Oxford has establishments that sell those types of animals as pets, does that mean that they are then customary in Oxford?
Well, the way the zoning board interpreted its own bylaw was to look at the two together. It's customary household pets. And even if this were to qualify as a pet, which I'm not conceding it does, again, I think you have to look at the term customary, which is attached to household pets. It doesn't just say household pets. And the fact that you're keeping 40 animals is not customary in the town of Oxford.
Thank you.
Going back to the original arguments, again, in my opinion, the record is clear that Attorney Pakula, who was representing the appellant at the time, waived any claims for relief under Chapter A, Section 3. She acknowledged and stipulated, she says, I'll stipulate that agriculture is not the primary use of the property, so my whole argument is that this use is allowed by right per the zoning bylaws. So any claims that the appellants try to continue to raise that this is in an allowed use under the agricultural exemption, in my opinion, has been waived by Attorney Pikula and is not before this court.
I don't think that's what happened there. I think what happened there was that Attorney Pikula was clarifying for the court that her clients were no longer pursuing a claim that the Dover Amendment permitted their business because their property was not 5 acres or larger. But she very clearly articulated during that same exchange, back and forth, whatever it was, that her clients were pursuing claims under the Town of Oxford zoning bylaws.
Correct, and we don't dispute that.
Okay.
We don't dispute that. And again, just to be clear, there's, a January 28th docket entry where the court again explains Attorney Pikula indicated her position is not on 40A Section 3, but the town's zoning bylaw, which we agree. And then, Your Honors, there's also a docket entry from a status conference where this is what the entry states, Pikula confirms that this is not, that if the use is not determined to be agricultural, this case would necessarily be resolved in favor of the town. And that is because Attorney Pikula also waived the arguments that if the use is not agricultural, that it would be allowed as a permitted home occupation, because she stated that they were not appealing the zoning board's determination that under Section 2.1.3, this was a use that may create a hazard or become a nuisance. And again, the bylaw is clear that home occupations are only allowed provided that they don't meet certain standards. And one of those standards, among others, and that's the 25% floor area, is that it can create a hazard. So by failing to appeal that section of the order, well, they now are stopped from arguing that this is not that this is a permissible home occupation.
So assume for the moment, and I'm certainly not forecasting anything here, assume for a moment that we concluded that we agreed with Judge Roberts' decision on that and said solely on the nuisance ground, nuisance having been established by the cease and desist order, affirmed by the ZBA, not appealed to our court, that is an adequate and independent ground on which we affirm the land court's order, and we're not going to say anything else about it. Wouldn't the appellant be able to then go back, because I understand from the record that the plan was to remediate whatever issues were found by the building inspector with respect to electrical cords and space heaters and so on. Wouldn't the appellant then be able to go back to the town and say, okay, come on back, building inspector, come look in my basement now, and you'll see that those, there's no odor, I have a brand new, ventilation system, and also all of the wiring stuff has been fixed?
I would say no, Your Honor, because the Section 2.1.3 and the zoning board's finding was that the use of the property may create a hazard, and the zoning bylaw doesn't require that it be a nuisance or that it actually create a nuisance, but the possibility that it can create a hazard is something that would prohibit that type of use as a home occupation. And here, where that finding has not been challenged, and the board found that there were certain items present at the use of the property that could create a hazard, I would say they're stopped even if they go back and fix those items, because the issue here was they may create a hazard. And so the only argument that they have is to say that this is an agricultural use under the town's zoning bylaws. And I think if the court were to make a determination that the breeding and sale of reptiles that are not native to New England, that can't survive in conditions less than 60 degrees, would really become a slippery slope argument. And as the Maryland courts in Missoula pointed out, this would, lead to an absurd interpretation that any type of animal would be allowed to be raised in a residential property under an agricultural use. So for example, we could have lion cubs being bred in a basement of a property that's less than 2,000 square feet in a residential neighborhood,
But you've
and
made
that's
a
allowed as
lot of
agricultural.
leaps there, right? I mean, my dog can't survive outside alone, really, for probably more than 20 minutes, because she's just really not that resourceful. But that doesn't mean that she's not native to this area or a customary household pet. So, you know, and a lion cub, I mean, these things are sold in pet stores. We probably all know people who have one or who have been lobbied by their children to get one. So there's got to be a difference between a lion cub and a bearded dragon. And so I think it's, you know, to focus on the case at hand, I think the question, one of my questions for you is looking at the definition of livestock. What is your best case for the proposition, and I mean best case since the passage of Chapter 48, Section 3, which I understand doesn't govern but has a cognate definition, that this can't be considered, this being a bearded dragon, livestock?
I don't think that there is a appellate case on point, Your Honor. I've searched for it, and that's why I point to the Missoula case, which, while we recognize, you know, is not mandatory authority, it is persuasive to this court, especially as this issue has not been addressed, where they say the mere fact that that a use is agricultural in nature does not convert that to the primary agricultural use of the land, or the Fink court, where they're talking about, you know, animals that are permanently owned and kept being allowed as agricultural. That's different than simply selling animals and breeding them in a basement as agricultural. And this is, you know, looking at agricultural use as that term is defined under, or as that term is interpreted by the and the purpose of the residential district in the bylaws, one of those purposes is to prohibit commercial uses.
Let me stop you here for a minute. I'm sorry to interrupt you, but I think we're going to have to ask you to leave your argument here. We do have your briefs. Thank you both for your excellent arguments, for your very helpful briefing, and the matter is submitted.
Thank you, Your Honors.
My thanks to the court officers and our law clerks. Thank you very much.